Yes,
Brady, do you manage that for us?
I do. Commissioner O'Connell Chapman,
Present.
Commissioner Adams,
Present.
Commissioner Davis, Commissioner Gilbreth,
Present.
Commissioner Stewart, Commissioner Gillette,
Here.
Commissioner Kuhns,
Present.
Commissioner Wilson,
Here.
Commissioner Clemens.
Here.
Thank you. That is everybody accounted for.
Okay, so the next thing on our agenda is new business, which is an opportunity for public comment. Anything that's not, no? Oh, first, old business. We have to do the old business first. So the old business is approving the February 19th, 2019 meeting summary.
Madam
And
Chair, I'm going to abstain from the vote since I was not participating in that meeting.
okay. And
And I'll abstain because I was in China.
do we have any comments on the meetings? Does anyone want to make a motion to approve?
Make a motion to approve the minutes from last meeting.
Second.
Okay, and all in favor?
Aye.
Aye. All opposed? No? All right, so the meetings are approved. That is all the old business. Now, if there are any public comments for matters not on the agenda, this is the time to come forward. Nope. Okay. That allows us to move into the first rulemaking for amendment to 6 CCR 177-2, Part 1, Section 1.7.3, regulations pertaining to solid waste site and facilities.
Good morning, Commissioners. My name is Joe Shefflin, Program Manager for the Solid Waste and Materials Management Program. Thank you for being here. This is a briefing. These slides are, many of them you saw at the last meeting in our informational briefing, but I thought I'd go quickly through them again to sort of refamiliarize us with the current state and the scheme that we have in place now and what we are proposing to change and the practical implication of that. Sometimes it's hard to see in the actual language of the rules what the practical applications are. So without further ado, the goals of the changes that we're making to the annual fee regulations were to revise the post-closure fees. Those are currently pretty high for small operators, and we wanted to rectify that problem. We also wanted to begin assessing fees at surface impoundments. We had made a commitment and the stakeholders had agreed to that commitment back quite a few years ago when we passed Section 9, or we did a major revision of Section 9, that we would begin assessing annual fees for some of the surface impoundments. And so we are bringing that to fruition, even if it is 10 years later. And then we wanted to add a category of annual fee payers for those facilities that would normally pay the solid waste user fee. But because they are inactive, they are not currently paying that fee, but they still incur responsibilities and time commitments and resource commitments from us. And so we thought it would be fair for us to add a category for those kinds of facilities. There aren't very many of those, but nonetheless. And then we thought, as we usually try to do whenever we look at a regulation, that we can update it and simplify it if possible. And I think we were able to do that in this case. So the current scheme for annual fees is not very complicated in the regulations. It's a sort of one size fits all at the current time, but it is set up by a very complicated scheme within the statutes. So right now, the annual fees are in Section 1.7.3 of the regulations. They're going to remain there. And the solid waste user fee, the tipping fee, applies at all attended solid waste disposal fees, and that amount is $70 or 70 cents per ton. And that applies to all landfills that are attended and active, the tire monofills that are active, and the E&P impoundments, but not the other impoundments right now. The annual fees then apply to solid waste disposal sites and facilities when the solid waste user fee does not apply. So if sites are paying the solid waste user fee, they don't pay an annual fee. So the annual fees then apply to facilities that are not attended, and that includes waste storage facilities such as non-commercial surface impoundments, and that's the fee that we've never assessed in the past. And then it applies to landfills that are closed, so they're in post-closure care and maintenance. They're no longer attended, so now it switches from the solid waste user fee to the annual fee. And then lastly, it applies, the annual fee applies to waste treatment facilities that are sort of oddballs, such as incinerators, composters, and medical waste facilities. And as I mentioned earlier, right now it's a one size fits all. Anybody that the fee applies to pays $1,000 per year. The statutes for this that set out the solid waste user fee, the solid waste annual fee, they're in different titles. One's in Title 25 and one's in Title 30. Those two statutes do not mesh very well. They use different terms or slightly different terms. So it gets a little bit dicey for us to interpret what the legislature meant. So one of the things that we're going to do, in addition to changing the rules today, if you agree to do that, is we've already developed and taken through the stakeholder process a policy that helps us also explain where these two fees apply and where they don't apply and which ones apply when, so that we can keep that for posterity's sake. So that we don't, when we go back and redo this again, we don't have to do what I've done over the last few months, which is try to figure out what exactly these statutes say. So as I mentioned, we took the draft regulations, the statement of basis and purpose, and the draft policy out to stakeholders, and I'll talk about that a little bit more in a second. So the major changes we're making, I think you remember from last time, do not amount to a lot of money at the end of the day, but I just wanted to show you where the changes are. So for active facilities, we're leaving that unchanged at $1,000 a year. For inactive facilities, we are going, so that's the ones that are in post-closure care. We're decreasing that to $500 a year. We've simplified the regulations, from collapsing it from a section that explained the annual fees for active facilities, and then it used almost identical language again to explain the annual fee for closed facilities. So we've simplified that, and then we've set two tiers of fees for the impoundments. The type A, or the low risk impoundments, are at $0, and the type B and so those are the higher risk ones, are set at $1,000 a year, and that's new, as I've mentioned. And then it sets 3 tiers of annual fee for composters. Class 1 are the very low risk, very small facilities. That's at $0. That's a decrease from $1,000. Class 2 is at $100. That's also a decrease from $1,000. And then the class 3 are the big facilities that also have complicated feedstock streams. And so that's still at $1,000. And then it adds the category for inactive solid waste user fees. That's the inactive facilities that are not yet closed but are no longer paying solid waste user fees. And that's going to be $1,000 a year, and that's new. So if you summarize that all up into this slide, which I know is a little bit hard to read, what you can see down at the bottom, is this working? Yeah, right here, is that the end result is that these fee changes add revenue of $22,000 a year. That, while significant to those fee payers, is not a lot of money. So what we're changing here is not having much of an effect on our budget. If you look at the column on the far right, most of that comes from adding the new type B impoundments. We estimate that there's about 30 of those. Only one of them is currently paying that fee. So the net change is adding $29,000 for the 29 new facilities. So that's the lion's share of the increase right there. And since we've already dealt with that stakeholder group years ago and notified them that they would eventually be paying this fee, we got absolutely no comments from that sector of facilities. So we had a stakeholder meeting on March the 18th that should be this year. We invited 95 stakeholders that we had on an email list. After that one meeting where we had about 25 stakeholders show up and participate in that meeting, we asked for some feedback on whether they thought additional meetings were necessary. They said no. The next bullet gives you an idea of who we invited. So it was a pretty broad set of facilities. And we did receive one set of comments, which I probably should have gotten with Randy and Brandy to get those incorporated into the new version of the regs, but I was late on that. So we've added the errata sheet that shows you which changes were made as a result of that set of comments. Mostly those were just good catches with respect to typos and wordsmithing, not substantive. So that's the end of that. You should have a copy of the regulations along with the errata sheet. Brandy, did you also give them the draft of the policy?
No.
Okay. Which is fine. So that concludes my presentation. So if you have any questions, I'd be happy to try to answer them.
Joe, question. I thought last time in my notes, I thought you were going to assess $1,000 per impoundment. This says $1,000 per facility. So if you had a facility with 5 type B surface impoundments, you're still maxed out at $1,000?
Yes.
Okay. And the review fee for the demonstration plans and the interim final documentation, that remains the same?
Yes.
Thank you.
I had another question. Joe, is there any plan to include in this at some point down the road non-E&P impoundments?
Well, those, yes. I mean, that's in this one. If all of these type B impoundments that I've shown right here, we estimate the number of facilities at 30. That is the non-E&P impoundments that we're adding. The E&P impoundments are already.
Oh, I see. So you're adding the non-EMPs in this round.
Yes.
Gotcha.
Yes.
Okay, thanks.
Joe, I'm just curious why you didn't bring the policy to us at this point. Does it make sense to have 2 separate hearings for the policy?
You don't actually have to take any action on the policy. It's just an
okay.
internal policy for us. We'll put it on our website. Anybody can use it to help explain. It just really gives a history, a summary of the statutes, and it presents much of the information in the policy is also in the statement of basis and purpose. But the policy just is for our posterity's sake, so that, we went through, me and our attorney went through a very exhaustive evaluation of all of that. And next time, I don't want to have the next person has to do that, go through that evaluation. So we tried to capture that in the policy.
Great, makes sense. Thank you.
Joe, one last question, just from maybe an educational perspective. So it mentions the $1,000 per year for the type B is to support inspection and otherwise track those impoundments. Where would that money have historically come if you had to inspect a Section 9 type B impoundment?
All of our fees are intended to pay for time and effort by our staff. So the document review fee that you asked about a second ago, that does that with respect to reviewing documents and approving documents. The annual fee does that for facilities that don't pay the solid waste user fee, and then the solid waste user fee does that for all the facilities that do pay the solid waste user fee. So for the type B impoundments where we have not been charging a fee for quite a long period of time, we've essentially been underwriting our efforts through the solid waste user fee.
Okay, thank you.
During the stakeholder process, all of those facilities that are now going to pay a fee when before they weren't, they were okay with, there were no objections filed with you about that. They were all like, that'll be fine.
Yeah, we I think did a pretty thorough job of reaching out to those facilities. Some of them participated in the stakeholder meeting. Many of them did not, but we heard nothing from any of those.
And what is the main motivation? Why does the department want to start charging them? You feel like those costs weren't being covered?
Yeah, we are essentially underwriting our efforts, like I just told Commissioner Gilbert. We've been paying for that time through monies out of the solid waste user fee. So our time is being paid for by a different fee that these facilities didn't pay. So now we're just saying, okay, it's time to make them pay for their own.
And conversely, the facilities where you're reducing or eliminating the fee altogether, what is the reasoning, the department's reasoning for doing that?
Well, for instance, type A impoundments, which are the low risk impoundments, many of those are essentially effectively regulated by our Water Quality Control Division because they occur at water treatment plants. So we occasionally have a complaint or some other thing that we go out to a water treatment plant for, but we generally don't spend time at those facilities, nor do we need to, so they don't need to pay the fee.
Thank you.
So apologies if you just answered this question, but maybe just asking it a different way. There's a net gain in the program of $22,000. That is to cover what? Administrative overhead? What does it cover?
It essentially covers just our time and effort, overhead all the way down through inspector time, permitter time.
Okay, thank you.
No more questions from the commission? I would invite anyone from the public to comment. Do we have anybody, any stakeholders, any? No? This is where we close. All right, we close the record. We are closing the record and we can deliberate amongst ourselves. Everyone feels, yeah?
I'd have one comment. I'll be surprised that the $1,000 per facility in the future will capture all your costs. I guess we'll cross that bridge when we get there. But I'm aware of a facility that has multiple type B impoundments that will probably take quite a, sorry, is this not deliberation?
This is not deliberation. You need to reopen the record.
Oh, okay.
Oh, sorry.
Okay, so before we move into deliberations, we're going to reopen the record so that commissioners can continue to ask staff questions.
Sorry. I guess it was more of a comment than a question. I presume you guys have evaluated that and decided that the $1,000 max per facility will be sufficient to monitor all those type B impoundments.
I think you're correct, Commissioner Gilbert. There are going to be a couple of facilities where we probably have to spend more time within any one of those subsections of facilities. There's probably one or two that are going to be more time consuming, but in aggregate, I think the $1,000 is going to be fine. The statute actually gives us up to $5,000 in terms of a statutory cap for the annual fee. So we're well below that. So if we decide at some future time that isn't enough, then we could come back to the commission and ask for that to be increased.
Well, that brings up one more comment, Joe, or question. Maybe it would be helpful to quickly review that statute that apparently was enacted 10 years ago or thereabouts to deal with this issue, and we just haven't caught up with it. Maybe that would help explain some of why we're here today and why we're doing what we're doing.
I guess I'm not following your comment.
Well, I think that at least listening to some of the questions and thinking about what you brought before us today, it feels in some ways like this is brand new, but in reality, it's catch-up work. In other words, there was a statute enacted some time ago that said that you should do this, and there was some reasoning behind that, obviously, and the department just hasn't gotten to the point of following up on that statute until now. So that a lot of the stakeholders obviously have been anticipating this. They knew it was coming. They knew kind of what the charges were going to be, that sort of thing.
Well, Commissioner Kuhns, the annual fees have been assessed for many years. So the original statute, I think, was put in place back in the mid to late 2000s that allowed us to assess an annual fee against facilities that weren't paying because of the tipping fee through the solid waste user fee. So we've been assessing the annual fee for at least 10 years, probably slightly longer than that. Over that period of time, we've realized that that fee was fairly high for some facilities just because they had difficulty paying the fee. So we wanted to adjust that. At the same time, back in the late 2000s, that was when we modified Section 9 and did a big update on Section 9, which is the surface impoundment rules. And that was when we told the impoundments that we would be eventually, in fact, that there was a paragraph in the statement of basis and purpose to that rule that said that we would eventually come back and put in place an annual fee. In that respect, we are somewhat tardy in doing that, but that's the only respect where we're not up to date, if you will.
Okay. Thank you.
I would just add a comment that I actually commend the department for going through this process. And I know it's something we've done on the hazardous waste side several times where you're going in and looking at where are you spending your resources and adjusting the fees accordingly. And I think this is really important work that gets done periodically because I think it is important to be looking at how things change over time. And so to me, this is something that makes absolute sense that you're reallocating monies to where your resources need to be committed. So I appreciate it.
Thank you.
Yeah, and Joe, I would agree. And I would mention one more thing. You talked about kind of being tardy. I think the reality is most of these impoundments hadn't been classified until the last couple of years. So it hasn't really been a 10-year lag, if you will. It's probably more of a 1 to maybe 3-year lag.
That's true. I mean, it took us quite a long time to, the rule laid out a process by which all of those facilities went through a classification scheme to decide whether they were type A's or type B's. And it hasn't been until recently that's been pretty much finished.
Are there any further questions for staff? Okay. We'll close the record and enter into deliberations. No? No deliberations. Well, does anyone want to make a motion?
I'll do that. I move that we adopt the proposed rules regarding amendment to 6 CCR 1007-2, Part 1, Section 1.7.3, regulations pertaining to solid waste sites and facilities, annual fees, as amended by the errata sheet with the same date, May 21st, and along with the statement of basis and purpose.
Second.
The motion has been made and seconded. All in favor, say aye. Aye. All opposed? The motion carries. Okay. That moves us into the second rulemaking hearing, amendment to 6 CCR 1007-2, Part 1, Section 3.3.8, regulations pertaining to solid waste sites and facilities, training requirements for solid waste landfill personnel. And I know I need to ask about recusals. Is this the moment that we ask? Is there anyone that needs to recuse themselves or declare any disclosures? All right, then we'll move forward.
Okay, good morning.
Thank you. Within the solid waste and materials management program. So if you remember, on February 19th, we came to the commission for an information briefing with a proposed rule to add some training requirements to section 3.3.8 of the solid waste regulations. And let's see. There we go. So we took that proposed language out to the stakeholders. We held a stakeholder meeting on March 6th, 2019. We got a pretty good turnout. There were about 30 stakeholders present, along with probably a half a dozen or so that called in. So I felt like we got a pretty good coverage there. Based on the comments, which I'll go over in a few minutes, we made some edits to that proposed regulation and sent it out again on March 22nd 2019 for additional review and comment. One thing that was an oversight on my part is that we had initially included as a stakeholder group the solid waste landfills, and there are some power facilities out there that have ash monofill types of facilities for coal combustion residues. They were inadvertently left off the initial stakeholder process. So we did send it out to them, although it was a little bit late in the process. There's about 13 of those facilities. All of them don't have CCR landfills. But we did get some comments back from Xcel Energy, and those were good. That was good feedback, and we incorporated those as well, and I'll go over those in a little bit. So if you remember, the initial rulemaking covered 3 topics. The training would require training in not just the recognition of hazardous waste and PCBs or polychlorinated biphenyls, but also in the recognition of any other waste prohibited by the EDOP, which is the permit for solid waste sites and facilities. Training in specific elements of the EDOP relevant to facility personnel's jobs at the landfill. And the third one required safety training. We got a lot of good feedback from the stakeholders. That's really something that OSHA already regulates, and the recommendations were to eliminate that requirement. And that seemed to make sense to us. So the newest version of the regs eliminates that. It now only requires training and recognition of wastes prohibited by the EDOP and specific elements of the EDOP for facility personnel. Which leads into the next definition. The original regulation didn't really define facility personnel. I mean, the intent was to require people who work at and are employed by a solid waste landfill to receive the training. But there were a lot of questions just because that term wasn't actually defined, and that made a lot of sense, of course, as well. So we did incorporate that into the revised section 3.3.8, paragraph A1, to try to give the regulated community exactly an idea of what it was as far as who needs to be subject to the training program, okay? And Xcel Energy had an additional comment on that, which I'll get to in a minute. So we added some additional clarification in the statement of basis and purpose. Okay. And we also got some good feedback on the record retention requirement. Originally, the language required record retention through the operating life of the facility, which a lot of people felt like was too extensive. And so to be consistent, this is kind of modeled after the hazardous waste rules. We brought that back into requiring the record retention for training records for 3 years, okay? As I talked about, we did add a definition to facility personnel in the language of the regulation itself. And based on Xcel Energy's comment, we added a few lines at the end of the statement of basis and purpose. So the regulation tries to identify what type of facility personnel are covered by the regulation. The statement of basis and purpose tries to clarify who is not covered. So the intention was not to include offsite contractors or consultants or temporary personnel who might be contracted to come to the landfill to perform temporary work. For example, a lot of times Department of Corrections personnel are hired to remove trash from the fence line. So although there might be some on-site training that they might need, that's not something that we felt like would be covered under this particular regulation, okay? Likewise, if you hired consulting firms to come in and collect groundwater samples, the idea there would be that those contractors are already trained and they wouldn't be subject to this training requirement, okay? In the regulation itself, there was a requirement for facilities to document that new employees didn't work unsupervised, which seemed almost like proving a negative. So we eliminated that requirement and just said, revise the regulation to require training within 6 months of being employed at the landfill, and then to keep those records for 3 years. Okay. So I'll go over, let's see. Okay. Another comment that we got from Xcel Energy was that a lot of the ash monofills are exempt from the requirement of having a certificate of designation from the local governing authority. And Xcel made the argument that those ash monofills are almost exclusively operated by offsite contractors. So they were hoping for us to include an exemption or exclusion for landfills that received one's own waste on one's own property, and that were operated by contractors. We didn't include that exclusion because we already felt like the regulation itself excludes offsite contractors from that training requirement. But we did feel like even someone who operated an excluded solid waste site and facility because it was their own waste on their own property, there would still be some requirements in the EDOP that they would need to be aware of. The EDOP is the permit for the facility. So if you don't really understand what's in the EDOP, it could lead to non-compliance. So we didn't include that particular exclusion, but we felt like we covered most of the intent through the regulatory changes. All right. A couple of cleanups. On line 30 of the regulation, we inadvertently left in personnel safety, and we did want to try to remove all the requirements for safety requirements in the training regulation. So that was just an oversight. And then there was a misspelling on line 90 of the statement of basis and purpose. So we did correct that as well. And that should be reflected in the information that you received. And then the last item is implementation of the rule. We didn't really include an implementation schedule in the regulation itself, but we realized that facilities are going to need some time to adjust their training or develop training plans. So typically when we pass a new regulation, we do sort of a compliance assistance type of outreach when we do inspections for a year, and then after a year, then it becomes an inspection item. So that's how we were planning on implementing these new regulations, and it's kind of consistent with how we approach new regulations as they're developed. Okay. And I believe that was all I had. So if you have any questions, I'll be happy to try to answer those.
Are the training plans submitted to CPHE for approval, or is that more?
No, the idea would be that the facilities have a better idea of what their operations are and their facilities. So those plans would just need to be on site as part of the operating record. We would, as inspectors, review those on inspections, but they don't need to be submitted to the department for approval. Okay.
Ed,
Yeah.
So I'm presuming there's an issue with training at the landfills?
You know, it's like any regulation. It varies across the board. The bigger facilities, we really haven't cited or found training issues. It's been more the medium to small size landfills where we've identified issues. And, you know, since this regulation, there have been two different consulting firms that have approached me saying, oh, what are the small landfills, the rural areas? And they're trying to do some outreach and get on board with some of the counties to develop some of that training. So I know that there has been a big push, and we've been inspecting those landfills on an annual basis. So I would say, yeah, there's still some work to do out there, but it does vary depending on the size of the landfill.
Okay.
You know, like any regulation, some are doing a great job. Some could probably use a little more help.
Fair enough. I was just kind of back to the monofills. I didn't know if that had been a problem.
You know, the CCR or coal combustion residue facilities hasn't really been a focus lately. I haven't heard that there have been issues with that. We are going to try to get out there and do some inspections this year to those types of facilities. So, but I couldn't honestly say that it has been an issue at the power plants. So.
Can you address Ed a little bit more about Mineral County, for example, submitted comments?
Oh, yeah.
Maybe what's being done to help some of the more rural and smaller entities that already kind of struggle to.
Yeah. Well, one thing that we're doing is for the small landfills, those that receive less than 20 tons a day, we're putting together a standard EDOP for those facilities. It's out for public comment right now, I think, that they can take that language, which does include a training section, and putting together an EDOP is a pretty expensive adventure, especially for rural landfills that don't have a big income. So with regard to Mineral County, they're familiar with that process. They've provided some comments. And I did talk with Janelle, who's the county administrator there. They think that they'll probably take that EDOP and, they might have to modify it, but that would be a big help for them as well. As far as the training requirements, there's only 4 personnel at the landfill. They don't operate every day. So really the training, this requirement shouldn't be that onerous of a process for them. I took some examples from the hazardous waste side because I was an inspector on the hazardous waste side for a long time, just to show them, like for a small facility, it doesn't have to be a multi-binder type of training plan. It can be a page or 2, identifying who needs the training, what level of training they are going to be provided with annually, and just records of that training. So I feel like through our conversations, she was happy, and they're going to wait and see what the EDOP template looks like. And hopefully that also will help them through this process. So, yeah.
And another question related specifically to the comments we received from Mineral County. It sounded like from the administrator's letter that this regulatory process was going to require them to add additional manned or staffed hours at the land site and would restrict the trash haulers' access. And I'm not sure how these two things equate and why that's.
And we talked about that as well. I think there was an impression that the regulation would apply to the haulers or people that are bringing waste into the landfill. And they have kind of an unusual situation because sometimes they do need to dump, after hours. And so they have access to that facility. But it doesn't apply to the haulers. So it shouldn't increase their hours of operation. They shouldn't need to have an additional attendant there. They don't need to hire additional personnel. So through our conversation, I think we got that squared away. But I don't think it should have any kind of an impact like that on any of the landfills.
Thank you. Appreciate that.
Ed, sorry, one more question.
Yeah.
So I believe you tried to address Excel's comment on consultants in the statement of basis of purpose.
Yeah. At the end.
Yeah. Is that consistent with an exclusion per se, as opposed to putting them in the rule?
Well, in the rule up front in 3.3.8A1, we tried to define what it would include. And we tried to get the point across that it's employees of the facility that are working on site. Through the stakeholder process, it came up several times. Well, what about consultants? What about contractors and temporary personnel? So the language at the statement of basis, it tries to clarify who is not included. You see what I'm saying? So currently the language starts off by saying facility personnel shall not include consulting staff. Maybe we need to broaden that to say something like offsite personnel contracted to collect stormwater samples or whatever. And not so that we don't get additional questions, say, well, I'm not a consultant, I'm a contractor, or I'm a temporary personnel. You know what I mean? So we could modify line 92 to include some language like that.
I think it might be beneficial just knowing if you're out in the landfill, clearly you're not going to have the statement of basis of purpose with you. And so, to decide what's facility personnel, is that consulting, is that not, is that temp, that might be helpful for you all in the field.
Right. I mean, we put it in statement of basis, but we could just add it as an add-on to 3.3.8A1.
The only comment I would have on that, just kind of as the counterpoint, is when you start saying who it doesn't apply to, it gets to be a little bit of a slippery slope, because then you're having to think of the whole universe of, it may not just be consultants and
Right.
be a number of people. And
Could have left out someone else who might be doing temporary work at the landfill.
If you do that, you need to be broad enough that the understanding there, the intent is understood. And I understand why you focus on who it does apply to. But if we go down the path of who it doesn't apply to, we need to be pretty broad.
Well, and agreed, and maybe the other scenario, in theory, you're hiring expertise to come provide a service, correct? You know, your consultant. So theoretically, if you're doing this right, they're already qualified and they're already trained.
Right.
So I see your point, Laura, but I do think there's got to be kind of this common ground where both sides understand what the requirement is. Because honestly, there's even more consulting efforts that you didn't include here.
Sure.
We have vegetation monitors, we have surveyors. I mean, you can go down the list forever. So I think you're right. You have to draw the line somewhere. So maybe we can be a little bit more clear in general without going to either extreme. Because honestly, when most of us read this, it didn't pop out that consultants weren't included in that,
And I
even though
think
they're not
that's-
facility personnel.
That's kind of the point too.
Yeah.
Chris. I think if it's broad enough to say that, I mean, you're saying that it applies to employees of the facility. So it may just be as broad enough to say, you know, anyone hired on a contract or temporary basis is not included here. But I'm just thinking that right now it's been named out by what they're doing. And I think that's going to be short-sighted because there's going to be a lot of things that go on at these facilities that may not fall into collecting leachate or looking at waste profiles or who knows what all they may be hired to do.
Is there a way to define that the organizations can define an actual employee of the facility instead of someone who is clearly employed by someone else who's working at that
Right.
facility?
Well, the intent of the rule is when they put together the training plan, they would specifically identify which classification of employees at the facility need the training, whether it's an operator or whatever, and what their duties are. And so the plan actually gives the facility enough, I think, flexibility to identify. And they could even say in there, it does not include consultants, offsite contractors. You know, another question that came up is, well, we send our waste profiles to our corporate office in wherever. Do they need training? Well, they probably need training, but it's not training that we can regulate. You know, it would be a separate thing. Just like you said, Commissioner Gilbreth, if a facility brings in a consulting firm to do work at the landfill, the assumption is that they have done their due diligence. They've brought in people who are qualified and trained. So there's no reason to us to duplicate that effort and try to regulate offsite personnel. I'm not even sure we can do that, actually. But so if you think we need to tweak somehow line 92 of the statement and basis, we can do that to say contractors and consulting staff, including but not limited to, something like that.
Correct me if I'm wrong. You wanted that actually in the reg though, not in the statement of basis and purpose.
Well, the difficulty, I mean, and I guess unless there's a guidance document, and I'm not sure this is worthy of a guidance document, when you're out in the field, what are you going to see? You're going to see the rule. You're, you know, clearly not going to see the statement of basis of purpose. So I think you could probably, it says excluding qualified, you know, offsite personnel, something to that effect. You could obviously argue about qualified, but again, you're supposed to be hiring somebody that knows what they're doing, so you shouldn't be getting, that shouldn't be problematic. But I don't, unless you can somehow say an employee of the company, the training program or plan only applies to employees of the company. And I don't know if you want to be that myopic or not.
Maybe paragraph 1, we tried to do that by saying all personnel who work at a solid waste landfill, employed by, work at, and are employed by.
So,
I mean, you could argue, well, a contractor's employed by them too, but.
well, I wonder legally, when you use the language that says all personnel who work at, does that by legal definition mean people that are employed directly by that facility? And then we have covered that issue? Is that, no, does not mean that.
I think that can be argued
Okay.
both ways, and I don't think you want to make that assumption.
Okay, so it needs to get at what we're trying to get at, we need to be more precise in that language so that it's clear we're talking about direct staff employed by the facility and excluding contract staff or third party is so that it's very clear. Because it could, what I'm hearing from you, Jennifer, is it could be interpreted that a contractor could fall under the definition of personnel who work at.
Why couldn't you just add a sentence in line 26 that just says just that this provision excludes contractors and third party that are properly trained or
Yeah, qualified
Yeah,
personnel,
whatever that is.
whatever you want.
And leave alone what you've already done.
It seems like it hinges on whose duties include implementing Section 3. Isn't it true that if you had support, consulting support, whose duties include implementing Section 3, you would expect them to be trained to the standard for that facility regardless? I mean, isn't that the qualification that you're looking for, that they achieve that same standard? So I'm not sure where we need to better that requirement. It seems clear on its face.
Well, I think it's fair to say they're meeting the standard, but I don't think they're necessarily wrapped into this new training program. That's kind of the rub, because in all honesty, a lot of those consultants tend to train employee personnel. But if you walked in today, if Ed walked in today and said, can I see your training program? They're not included. And so I think unless we add, that one line, it's going to be potentially.
That's a little concerning. I mean, going back to Commissioner Kuhns' question about the haulers and it not applying to the haulers in Mineral County, where's the control on those off-hour haulers coming in? Is it applied by the employees the next day when they come in and examine the load? How do they?
That's my understanding is that, yeah, the next day when the facility operator arrives, they would do some sort of screening on that.
Wouldn't that be accounted in their EDOP? It would be what's written in their plan, and that's what they're trained to, correct?
Well, the facility people, yes, but not the haulers. So I'm okay adding a sentence at 26 if the commission is okay with that. Commissioner Davis, did you have suggested language for that?
I just think it just needs, I think it just needs to be a sentence about what's excluded. I think you've put what's included, but just a very simple statement that this does not include contractors, consultants, and other third parties that are qualified.
Yeah.
Or however
Make sure you
I think
put
Chris said it better than I do.
One caveat, I guess, that comes up to my mind is, Ed, you mentioned that some of the facilities hire Department of Corrections staff to clean trash and that sort of thing. So they're not technically qualified under anybody's EDOP, but you want them excluded, right, from the training plan?
Right.
So
Really what we're
how do we
talking about,
incorporate
yes,
them?
is employees of the landfill that are
Yeah.
conducting operations at the landfill related to solid waste operations. Yeah.
That's kind of
So
what I meant by
excluding-
being careful, because
Right,
geez,
right.
what if you bring in custodial staff, or they're not germane to really what's going on at the facility. It's more, those are kind of periphery jobs, to do things. So I don't know how, that's what I was saying is I don't know how broad this needs to be, because there's a number of different things that could come
Well,
up.
wouldn't the definition of an independent contractor under just the definition of independent contractor that's used for any kind of work where they are not under the direct control of the facility, they're expected to have their own insurance and, they have their, I guess what I'm getting to is, can we use the term independent contractor as our exclusion to cover a variety of people, consultants, people, Department of Corrections people who are brought in separately, other kinds of contractors, because they're not operating under the direct employee regulations of that facility.
Would it be expected that the EDOP would define who is included in facility personnel?
The EDOPs vary a lot. I'm not sure that they would all consistently define that. Some, I think, do and some don't.
Is there a way to tie that in? I mean, somebody approves that EDOP.
Yeah, I don't know. We'd have to go through each EDOP individually and try to figure that out.
Because it seems like we're trying to go through scenarios individually now and trying
Right.
to figure it out. And I agree with Commissioner Davis that when you try and define what's not included, it gets slippery quick. And some independent contractors will fall under these requirements, I would think that's possible, that they have these duties?
Ed, I have a question. So some landfills hire independent contractors to run the facility. So how does this apply to that? Because they're a contractor. And if we're excluding them, then there's no training for those folks?
Well, that's, I actually looked at the EDOP for Hayden Station because they have an ash monofill and they hire contractors to run the facility, the disposal of the ash and all that. But the EDOP does specifically say that the facility manager, who is an employee of the facility, is responsible for overseeing those operations of the contractor. So I would say, yeah, there's probably someone on site. There must be someone on site who oversees the contractors who would have that responsibility and who should also have that training. Because if you're not familiar with what the EDOP says, you're not going to be able to oversee the contractors. And that just seems to me to be common sense, right? If a facility hires people that aren't qualified, the liability is on the facility. If the facility isn't overseeing their contractors, it's liability for them as well. So I would say, while those contractors might not be subject to this training plan or this training requirement, it certainly doesn't mean that they don't need training, whether it's a requirement or not,
So,
Well,
oh, sorry.
sorry. Well, I like the suggestion of a qualified independent contractor. I think that gives you enough opportunity, even if it's Hayden Station, for example, that doesn't have, let's say, employee, it's all consulting. If they have a problem, then number one, they're probably not qualified. And number two, Excel or whomever is responsible for the management of that station regardless.
And the term I was searching for earlier, the Department of Labor has definitions for independent contractors. And if you attach that qualified to it.
I mean, I don't know who would really fall through those cracks because I still
Right.
think if you showed up and did an inspection and there was a problem and it was performed by a consultant, then you would still assess a penalty to the facility and then whomever would have to show that, well, clearly these guys weren't qualified and there's a problem.
Right. I mean, I think it still comes back to the landfill.
Yeah.
It's ultimately being.
Owns a landfill.
Sure. Okay, so do you think we should just add a section or a line to 26 clarifying that?
So one of the things that we seem to be going around is people that are coming to the landfill, like their correction facility, that would not be implementing Section 3 are not going to fall under this rule.
Right.
And because presumably they're not engaged in activities that pose a risk. And the contractors were going around the qualified. Those people we're assuming are trained. They have a training plan. Rather than the landfill having to create a training plan for them, if they're going to do work that involves implementing Section 3, could they be required to submit their training plan to the landfill that's contracting with them?
Yeah, we wouldn't require a training plan for those contractors, but I mean, Commissioner Gillette, you work at Larimer County Landfill. So when you hire a contractor, as part of the contract, is there something in there that says you have to meet these qualifications or you have to be trained or will be trained in the operations and the EDOP? Perfect.
Because I share the concern that excluding them opens up the possibility that you have people working that are unqualified. And we certainly don't want to leave a gap in the rules that allows that.
So I'm not sure how to include that as a regulatory requirement. Do you want to include something like that in the statement of basis or?
If I follow what you just said as written, you believe it meets the requirement to make sure that anyone implementing Section 3, whose duties are to fulfill Section 3, are trained.
Have to provide some sort of training plan to the landfill. The landfill doesn't necessarily have to create that training plan according to how this rule is written. If the consultant has a training plan and they've qualified their personnel, they can just provide that to the landfill
Or
to
a
allow
summary.
their staff to implement Section 3 at that facility.
Or a summary of their qualifications.
Would that meet that? Because I'm trying to do, I think what we're trying to do is both things. We're trying to make sure that we're not putting an onerous burden, especially on the smaller rural landfills.
Right.
But at the same time, we're trying to ensure public health, environmental health, and safety by making sure anybody that's possibly doing something dangerous or interacting with
Right.
something dangerous, that they're trained.
I understand what you're saying. I'm just not sure how we make the jump of regulating a Section 3 landfill and requiring training for contractors who might work there. I mean, it seems like, if they're not a facility person, a facility employee, I'm not sure that we can actually require a consulting firm to provide training records to the landfill. Can we? It's not
We're developing.
something we regulate.
We're developing a model EDOP or a standard EDOP.
Yeah, for the small landfills, yes.
And would it be appropriate that there's something in there that would say that anyone who's implementing Section 3 would have to, have the proper training or provide some kind of evidence of training?
I'm not sure. Wasn't involved in how that EDOP was prepared. I think it's still draft, but we could look at that and try to add some language in there. Sure.
I see that requirement as an additional burden on the facilities, especially the small ones. Would there be personnel at Mineral County who would be capable of evaluating a contractor's training plan?
Well, Mineral County is very small.
That's why I'm concerned.
I imagine they do have a contracting process though, and they try to hire qualified people. I mean, that's.
Some of this makes me nervous in hearing this discussion because it gets into the same thing on the OSHA side with looking at adequacy of safety plans. And I just feel like we're getting too far into means and methods, and what we need to be focused on is just making it clear on who this applies to. And I think we're getting now more into too much of the actual mechanics around it. And so, this may be one of those things that we have to revisit if there's an issue. But I feel like there is a responsibility when you go on any site, even if it's not being trained to EDOP, you're getting trained on something because you're going on someone's site. And OSHA covers some of this, and that's the reason safety got carved out of here, because it's already covered. There's multi-site employer, different responsibilities along those lines that would already, again, be covering some of these people that we're talking about. So it's not like they're going to just walk in and get no training at all. It's just we're focusing here on the EDOP itself and what they need to know for the actual operation of that facility, and what it's designed to do. And I don't think that that's a big number of people that need to understand that, other than the people that work there. So I think we need to kind of maybe come back to what we're trying to accomplish with this paragraph.
Well, agreed. And that was kind of my first question about, is something broken? So arguably, if you guys go out to a landfill today and there's a training issue, even though there may not be a training program, I think you guys have all the authority and ability to assess a violation, a concern, et cetera. So, by creating this training program, that's where we start getting into what's in, what's out, who's in, who's out, that type of thing.
Well, and I think a lot of this can be resolved just through the facility putting together the training plan and specifying who is in and who's out. And if it specifically says in there, this does not apply to offsite contractors, it doesn't apply to, people at the corporate office who are doing oversight on any kind of operation. The plan is really the facility's opportunity to tell us who needs the training and what level of training is needed. I mean, it's difficult for the division to try to narrow down which type of person at every single facility is going to need the training, and there's just no way we can do that.
So is that what we should focus on maybe there then, instead of who's in and who's out, to say that it needs to be documented?
Yeah.
Who it applies to needs to be documented in the EDOP, and leave it at that.
And I think that's what the intent of paragraph B is intended to do, put together the training plan and tell us who needs to have the training and what level of training needs to be done. I think that's how you get around this whole issue.
And I think that by having your statement in the statement of basis and purpose that explains really what the intent is, that will help reassure the smaller operators that we don't intend to regulate the training plans for
Right,
their contractors.
right.
Well, we've partly come full circle because now theoretically it's the language as is, right? Which doesn't potentially exclude qualified independent contractors. So the question is there a reason not to put qualified independent contractors in the actual rule as opposed to the statement of basis of purpose?
Well, I think the question that you want to ask is whether or not the rule as written is clear enough and understandable enough for someone who needs to implement it can follow it.
Well,
It's
based
not
on
so much like who's in and who's out. It's if people can understand it and follow it.
And I guess the thing to me is when you went through the stakeholder process, was it clear to those people that the way this is written, they are identifying who they are including in the training plan?
I don't think it was initially, because initially we didn't have the definition of facility personnel in there. Once we added this language, there were only a couple more questions about the haulers, about people at corporate, consultants, offsite contractors. But I think, yeah, after we added the definition, people had a pretty good idea of what we were talking about.
Well, and I'm just kind of going back to Excel's comment. So clearly they didn't. So they provided language, which you all put in the statement of basis of purpose. So that's where we are in terms of clarification. So I don't know if the commentor feels it's been clarified because it's now in statement of basis of purpose.
I don't know. I mean, I did respond to commenters' concerns. I haven't heard back yet. So, but again, I think even a facility like Excel that has a NASH monofill, there would be some level of training that would need to be done, whether it's specified in the EDOP or a separate plan. And if they're relying on their contractors, then they could spell that out and tell us exactly who needs to be trained. And that's the intent of the training plan. So.
And in your original language, you had trying to document for 6 months, this person will not be engaged in activities if they haven't been trained yet. And you removed that as a result of Excel's comments?
Well, initially the requirement was that the landfill had to document that they did not work unsupervised.
Right.
So we struck that part of the requirement, but still, I think it still says that they can't work unsupervised until they get the training, and the training has to be done within 6 months.
So what was the reasoning behind having that original language?
It was just an additional check to make sure that facility people were paying attention to it. But if the reality is, from what I've seen at landfills, is people are not going to be brought on site as new hires, and they're not going to be working unsupervised. There's just too much risk and liability. So, we went out to Front Range Landfill. We talked about this, and immediately they implement a multifaceted training plan on safety, on whatever their job is, implementation of the EDOP. And so, I think the training is taking place. I think they're documenting it. But to document that they haven't worked unsupervised, it just seems a little far reaching. So we agreed to take that out.
To follow up on the point about stakeholder participation today, because it sounds like there's been, obviously reading, there's been some back and forth. I think you made the statement. You don't know where they stand. I assume we didn't get a blue card today and they're not attending to make comment today?
I sent them the revised proposal, and Ed sent them the revised proposal. I also let them know that they were free to come answer questions, and I did not have any response to my emails.
So they did not say, for example, we don't have time to show up.
I got no response whatsoever.
That's helpful to know. Thank you.
Can you point out, Ed, where it says that the employees will not work in those areas until they've received the training? I don't see it in there anymore.
Let's see.
It says number 3, it says documentation that they've received the training within 6 months of being initially employed or being transferred. It doesn't say anything about not working without the training.
Okay, that
That's
was,
just assuming that you want to have it in there. It's not in there that I could find.
yeah, so that was probably just an oversight. So we could strike the documentation and add that they will not work unsupervised until they've had the required training.
I don't know. I think we should just leave that the way it is.
Yeah, okay.
I was just,
I think it's implied, but
All right. Joe thinks we should just leave it.
I think on some of this, like in hazardous waste, it doesn't say that you can't work unsupervised until, I think it's more about making sure that they have a training within a specified period of time. So I'm comfortable with it, how it's worded.
Okay. That's,
well, I just wanted to make sure that it was on
Okay.
the record that
Yeah.
it's not in there. Yeah.
Any further questions for staff?
so one thing, just as an idea, so we are going to be doing a compliance assistance and outreach for a year. If this time next year you want us to come back and say, give you an update, we can do that as to whether the whole contractor offsite personnel thing is working, or if the training plan is sufficient to capture that. I mean, we could come back and provide you an update. And if we are seeing items that aren't captured by the rule, then maybe we could revisit it at that time. I don't know.
I would be in favor of that because I really think we need to find out if there's really a problem with this or not. If it's just Excel's perception or if it's a more widespread problem.
So I just want to provide some clarification. So far, we have settled on accepting the most recent revisions as is, with the caveat that we will request an update a year from now to see how this is going. Just so that before we close our dialogue, he understands what we're asking. Yeah? Okay.
That would be part of a broader review of enforcement in any event. Because at the end of the day, this really comes back to what are the signals around the effectiveness overall. I think focusing on one component is helpful, but there's a broader program that you all are trying to implement. And I think that would just be part of that discussion.
Right.
Which is fair, but my last point will just be, if we're implementing new language, my presumption is something needs to be improved, it's broken, et cetera. So I just want to make sure we know what we're getting by just, as opposed to just throwing in additional language. I'm fine with Ed's suggestion that a year from now, we assess the health and clarity and that type of thing. It's just, if we're not exactly sure what we're trying to fix, I think that's where we get into fuzz on who's in, who's out, what's applicable, what's not. So I'll leave it at that.
Just to follow up on that, so the basis and purpose indicates that there's basically a gap in training requirements. That's what it says, if I understand it right. Is that correct? Or-
Yeah, yeah. That's what our inspections have been showing, is that, yeah, there are problems at some of the landfills, and a lot of those problems stem from not having facility personnel that are trained in what prohibited wastes are and the requirements of the EDOP. We saw the same thing on the hazardous waste side. When you go to a facility, you do an inspection, you find 10 or 15 violations, and it all stems from facility personnel don't know what the permit says, or they haven't been trained.
Everything
it's
starts
kind
with, do you know what your job is?
Right,
Basic table stakes.
right.
And the main purpose of this is to tie the training to the EDOP. That's one of the gaps that you've been seeing,
Exactly.
is that they're getting some general training, but they're not necessarily getting the training that says, at your facility, you have agreed to do these things.
Sure.
You need to be sure that you understand how to do these specific things.
Right.
Because that's what your permit.
Yeah, and
requires.
again, it's not tied to the entire EDOP, it's tied to the requirements in the EDOP relevant to what that person is doing at the facility.
I also feel like what Ed brought up earlier in section B is we have to look at this in the context of not just that first definition, but also what paragraph B says. And that paragraph is telling you to include in your plan who you're going to train and why.
Right.
So those things working together, I think, kind of put it back in context.
Any more questions? We would open it up to public comment. Is there anyone in the audience has anything? No? Okay, so we close the record and enter into deliberations amongst ourselves. Did you want to, how are you feeling about that statement of basis and purpose lines 92 through 94?
Maybe the suggestion that it's more general and qualified independent contractor would apply there. I mean, there are a few operational consulting jobs that you don't capture there, Ed. But that's a light suggestion. I'm comfortable with the philosophy of a year from now, we come back. If people aren't getting assessed training, administrative training issues, then I don't think most companies will have a problem.
But you also like the idea of perhaps we could add the word qualified. Facility personnel shall not include qualified consulting staff
In the statement of basis,
in the statement of basis and purpose.
that's fine.
That would be an idea to entertain. Any other comments on that?
My thinking is, we've gone around the bush on this one a couple of times, but it seems adequate as written. It seems as we try to define it more, especially sitting at this table outside of a stakeholder process, that's not a wise thing to do, to just start sort of tinkering with the words. So where I'm at is, I think it's adequate. I think training is something that I'm passionate about. People, first and foremost, understanding what they do, and this seems pretty tightly written around that. So
Jim, just for clarification, that language was added in response to public comment, not as
Understood.
part of the stakeholder process. So,
Oh, okay. So you're defining outside
yeah,
of
just so you know
stakeholder.
that.
Got it.
But you also had concerns about maybe that should not be part of the statement and purpose.
I think, again, after kind of talking through what all the different options are, I would prefer to leave things as they've been proposed today and revisit this if it is an issue. I'm not even saying that we have to hear this again in a year, but I think if there are issues with this, it should be brought back here, and we should then try and clarify it further with proposed language, to Jim's point, so that we're able to make better decisions instead of wordsmithing. So I'm kind of where Jim is. I'd like to just leave it how it is today and vote on it as is.
I would agree. I think we run the risk of having unintended consequences of adding language that then doesn't mean what we intended it to mean, without a lot more thought put into it. So,
Well, I have a slight concern, as Jim pointed out, that this language was added because of one stakeholder comment. This wasn't brought out to everybody. We responded. However, that stakeholder had a very well thought out comment, so.
So I think we have, after our esteemed council reminds us that it wasn't part of the stakeholder process again. So I think it's fantastic that we were able to bring in, that the division was able to bring in the additional concerns at a late hour. And, Ed Smith saying that was an oversight on his part was courageous, and I commend that as well. I don't know if that's fair, but well taken.
So I just have one comment to make, actually. So this is the statement of basis and purpose, and that language is more like a rule because it's a shall not. And so typically we don't put that kind of language in our statement and basis of purpose because it becomes confusing for what's rule and what's not rule. So I would recommend making that language more like is not intended to, only to avoid that kind of confusion for readers.
So you're saying, Jennifer, change it from shall not to is not intended to.
that makes sense.
Yes. But shall is rule language. So
Right,
this is
okay.
your statement of basis.
Removing the shall, replacing that with is not intended to include.
The only other thing that I would say is precautionary, and I'm certainly not proposing to change this again today because we've discussed it ad nauseum, but I think the thing for me is I'm always cautious about like how this is written, where there's specific tasks that are put in here. and without understanding the whole universe of what people that are hired to do consulting may be asked to come in and do. And so, again, the question could come up, if I'm not there to collect groundwater samples or methane or conduct, what if I'm coming in to do the training? There's a number of other different things that people could be coming in to do. And so in the future, I would just be careful about getting too specific, even about what the job requirements or what the specific tasks they're doing, because it can be much broader. And we've talked about a few of those sitting here today. So that would be my only other word of caution. But again, I don't feel like this needs to be changed today.
How about, for example, groundwater sampling,
Including
surveying,
but not
whatever?
limited to, something like that, yeah.
Would you feel better about that?
I think I would, just because I think, it's getting too much into defining what someone may be coming to do.
So the two things we are looking at is changing shall not to is not intended to include, and then include consulting staff employed by the facility. I mean, we'd have to change that sentence a bit for it to make full sense, but something along the lines of is not intended to include consulting staff employed by the facility to, for example, and then the list that's there. Or it could just say shall not include consulting staff employed by the facility. And we could strike all of the specific task language.
Or consulting staff employed to conduct duties such as, for example.
Council, do you have any thoughts?
I think, well,
That's not a legal question. Like, this is wordsmithing. That's
Okay.
really up to the commission to decide. I can make suggestions if you would like, but this is really something that the commission should be deciding, not legal counsel. If you come across a legal issue related to your wordsmithing, I will speak up.
maybe we could just say facility personnel is not intended, additionally, facility personnel is not intended to include consulting staff or other off-site personnel who are contracted to perform activities at the landfill. Because I'm not really sure that we have authority over non-landfill facility personnel. And just make it short. That way it covers everybody. Would that be an option?
Yep.
Okay.
Good with that.
That works.
Okay.
So it is my understanding, in order for us to make a motion on approving it, we have to have the specific wordsmithing done before that motion is made.
Yes.
And could you read again your
Yeah.
suggestion?
Okay. So how about if we say, beginning on line 92, additionally, facility personnel is not intended to include consulting staff or other off-site personnel who are contracted to perform work at the landfill or the facility. Probably landfill, since that's what this section applies to.
Commissioners, any thoughts on that language?
The only additional thing you might want to say is, has been stated, qualified and in front of the staff, qualified consulting staff, which has been bantered around.
Then we'll have to decide who's qualified and who's not.
I think that's a very subjective term that needs
And we'll leave it out.
definition.
Although that's what they have to decide.
That's true.
Exactly.
Well, it's up to the facility to tell us who their responsible parties are at the facility and who needs the training. That's all we have to decide.
Yeah.
We're going to review the plan and the training based on what the facility tells us they need. And we're not going to go out and say, oh, someone's pulling weeds on the cover. Do they have training on how to pull weeds? No, we're not going to do that, right? I mean, we're going to evaluate what the facility tells us and whether that training's been performed.
I
And
would
it's
offer that the
performance-based.
wordsmithing is taking us right back to where we were. The question in my mind is still what was asked by council. Is it clear? do folks have a way to define in their plans who's in, who's out? If that's not true, I would say, let's have the division go back to, stakeholders and other folks, because right now we're talking about addressing an issue that has not been defined by either the stakeholder process or other comment from the public. It hasn't even been brought to us as an issue. Seems a bit odd to be implementing suggestions around this.
I would propose that we kind of do a hybrid, and that's leave the rulemaking, the regulatory language, how it is, the definition of facility personnel, and that we do amend the second portion, lines 92 through 94 of the statement of basis and purpose, just to make it more clear that if you're not in one of those tasks, you still don't have to have this training.
What about the suggestion that the basis and purpose just clearly state that, identifying who is the personnel that are covered is put into the EDOP?
I think then we're just reiterating what's in the rule.
That's what I think too. That's why I think it's not needed to put
The only
the
thing I would
extra
say is this is
clarify.
intended to clarify. And so I actually like the statement that you made where it says additionally facility personnel is not intended to include consulting staff or other offsite personnel who are contracted to perform work at the landfill. I think just making that statement and taking out what they're there to do just makes it clearer.
I would say it makes it less clear for me, because if those people are implementing and have duties to do the Section 3 requirements, that's what I'm getting hung up with.
Madam Chair, I'd like to put a motion on the table that we can then react to. Does that make sense?
Yeah.
Kind of get us off the, on the ball or off the ball or something. So I'm gonna attempt this, and Ed, you may have to help me with your language. So I move that we adopt the proposed rules regarding amendment of 6 CCR 1007-2, Part 1, Section 3.3.8, regulations pertaining to solid waste sites and facilities, training requirements for solid waste landfill personnel, and an amendment to the statement of basis and purpose, reading in lines 92 through 94. Additionally, facility personnel is not intended to include consulting, or is not intended to include consulting staff employed by the facility who carry out duties. I can't remember the last
Yeah,
of
I
your
think-
sentence.
It was additionally, facility personnel is not intended to include consulting staff or other offsite personnel who are contracted to perform work at the landfill.
Thank you.
Are there any seconds?
Second.
A motion has been made and seconded. All in favor?
Can I just
Oh, whoa, sorry. Discussion, sorry.
clarify, because I didn't hear the revision dated May 20th, 2019. I don't know if I heard that today.
Oh,
Because that's what we're talking about, right? The
Right.
Revised.
oh, okay. I'm sorry. Yes. So that the amendment of 6 CCR 1007-2, Part 1, Section 3.3.8, regulations pertaining to solid waste sites and facilities, training requirements for solid waste landfill personnel as amended, the date,
The 20th.
May 20th, 2019, and the suggested correction to the statement of basis and purpose.
And is there an opportunity to say that those consultants and offsite folks whose duties do not include implementing Section 3? Because that's my only hangup.
You can amend the motion.
I don't know if I can amend that motion.
I'm not going to amend the motion, but you can.
Are
You
you
can.
talking about in the statement of basis and purpose or in the rule itself?
That statement of basis and purpose as proposed to be revised to exclude the consultants and folks who do not work at the facility. And for me, clarifying that their duties don't include Section 3 of the regulations and the requirements of the EDOP or the landfill.
So I'd prefer not to amend my motion, but we could, I assume, vote on that and then you could make a new motion.
And I don't know, do I have to re-second her motion since she amended it?
Well,
Oh, yeah.
So motion made, second.
I
now we're
corrected my
talking about a
motion.
potential amendment.
so you can second her amended motion first.
So be it. I am a second on the amended motion made by Commissioner Kuhns.
Okay, and then Jim, you want to make a friendly amendment that's been rejected. So the motion on the table now is just Teresa's, seconded by Laura. So if you want to vote on that, you can vote on that.
But I can also, there can be further discussion.
There can be further discussion.
Is there further discussion on the motion as made? Okay, so we will vote. All in favor of that motion?
Aye.
Aye.
All opposed?
Opposed.
The motion carries. And it is approved with noted amendments.
You're right.
Thank you, Ed.
Okay,
Can we break for a bathroom?
yes, so we are going to pause the meeting, break. We're taking a break, taking a 5-minute break.
That was very interesting.
What's that?
I share.
No, I get it. I get it.
Share your concerns. However, I do think that this regulation is pretty redundant to a bunch of other regulations in terms of the OSHA safety and their EDOP.
Sure.
Those other things, but
And I share Laura's concern that once we start excluding, unless we're extremely broad in our exclusion, then we've got to be, we open the universe. So, yeah.
the thing about you want staff to come back in a year.
Yeah, I have a note,
That's
so,
just a no, I don't have to do anything.
no, so what I'll do is I'll just add it to our calendar, so we have like a calendar that goes out, so when I have things like this, I just add it to it, and then when those agendas come back, I remind them, hey, you've got to present something.
Come back and say, it's going great.
Yeah. Like, no.
In an ideal world, but how much control do we have?
We have to put this up now because you can't stop the YouTube. And we're gonna change the link, so it's like, we're on
That's funny.
Yeah, it is really funny. I guess that works.
I've been impressed, surprisingly. It's pretty between IA, LA,
Yeah, so I propose, like, when we finish the hearings,
Yeah.
we should get through, like, for update, the legislative update and the commission business, that way I can shut everything off and like we have no business.
Perfect. I like it. I like it.
So can you educate me
Yes.
on a couple things?
Sure.
So in theory, when we're
We have a lot to get through today, so let's bring it back.
Yeah, you probably don't miss that drive over.
I don't. I mean, it'd be like beautiful, but, you know, and partly because I was on city council at the same time. We had our meetings on Thursday nights.
Okay.
So something that I could afford to get on the road to get here by 9. It was, it started at 9. Yeah.
So this is a busy week for me, and I have this and an HOA meeting, plus I have a big meeting at the National Western Center. A lot of stuff going on out there.
And we haven't excluded them. We've just said that you're We need all the commissioners to return, please. Can I call it back before they're sitting down?
Excuse me.
You know,
We'll get you a gun. Instead of dropping us like flies.
I just got to bring a bigger gavel, right?
Well, that one makes plenty of noise.
Right, give everybody a chance to sit. Okay, Brandy, we're good? The meeting is back in session, and it is time to move on to the rulemaking hearing about amendment to 6 CCR 1007-3, Part 6, regulations pertaining to hazardous waste, solid and hazardous waste commission fee.
So this is, I'll present this for you. So this is a hearing. The Solid and Hazardous Waste Commission fee is actually the fees that maintain the operation of the commission office. So that includes me, that includes any reimbursements to you, any expenses that we have during any meetings, any supplies that we might order, improvements to our facilities that the commission benefits from. And the attorney as well sometimes. And so this fee has been in place since the creation of the commission in 1992 and has not changed. But this is merely to change the fiscal year on this regulation so that everybody knows when it's applicable, 2019, 2020 fiscal year. This is probably the easiest hearing that you all have.
And
here.
you have assessed the fee, and the current fee is
The
enough to
current fee
cover
is,
all
yeah.
all expenses.
It maintains itself.
And you're limited to a 1-year period?
Yes.
Yeah, the statute requires you to revisit this every year.
Any questions for staff on this? Any public comment? No? All right, we will close the hearing, open it to commissioner discussion. And if there's no commissioner discussion, is there a motion?
Here we go. I move that we adopt the proposed rules regarding amendment to 6 CCR 107-3, Part 6, regulations pertaining to hazardous waste, solid and hazardous waste commission fees, and the accompanying statement of basis and purpose.
Second.
Motion has been made and seconded. Any discussion? Nope. So all in favor? Aye. All opposed? The motion carries unanimously. Look at that, Brandy. You're so, look at that.
Yay.
So that allows us to move on to the next rulemaking hearing. which regards amendment to 6 CCR 1007-3, Part 260, 261, and 262, regulations pertaining to hazardous waste, safe management of recalled airbags.
Oh, that's not
It's the
good.
font that you use
Well,
for survey.
you can look at it from this view maybe.
Yeah, that's what they use.
Okay, I can move it for you, I think.
Okay. Good morning, Commissioners. I'm David Foster, and I'm an inspector with the Hazardous Waste Compliance Assurance Unit. The first proposed rulemaking today is something we visited at the informational back in February regarding the proposed rulemaking regarding the safe management of recalled airbags, more kind of specifically the Takata airbags. In overview, we'll look at the regulation of used airbags under RCRA, kind of for the folks that weren't here, kind of give you the what the rest of the commission saw in February and what the proposed rulemaking will be. Why there is a recall on the Takata airbags, the goal of the proposed rulemaking, and an overview of the actual proposed rulemaking. So first off, how are airbags typically regulated under RCRA? There is an explosive propellant. It does exhibit the hazardous waste characteristic of ignitability and reactivity. Typically, used airbags or unused airbags there's different RCRA exemptions and inclusions that can be applied to airbag waste that kind of gets them out of certain aspects of haz waste regulation. Those will not be affected by the proposed rulemaking today. But because the Takata airbags and some other recalled airbags, as you'll see later, this doesn't apply only to Takata. But because they have been removed from vehicles and they're going to be discarded, they do not get the RCRA exemptions and exclusions and therefore have to be managed as a hazardous waste. And this is why we will have the kind of a new standard for management for these airbags. The Takata airbag recall affected 65 to 70 million airbag inflators. Basically, there was a metal inflator. Inside the airbag, it would rupture, explode, and cause injuries and also death in the U.S. and throughout the entire world. What happens is the PSAN, the phase stabilized ammonium nitrate, degrades over time in Takata airbags and can cause the inflator to overpressurize, causing deployment when it should not be deploying. And these are, I mean, it's like a shrapnel. It's almost like a grenade going off, which cause these injuries and or deaths. So what's the goal of the proposed rulemaking? Want to ensure quick, swift removal of the Takata and other recalled airbags out of the auto industry. Ensure that just because we're doing a swift removal, getting rid of all these as quickly as possible, that they are still being managed safely during their accumulation, transport, and that they are appropriately tracked to their final destination. And also to ensure that there are no missteps or people are not reusing these recalled airbags and somehow getting them back into vehicles that will be driven by the public. So the crucial element of this change is that the airbag waste is going to be properly disposed of at a haz waste facility in a timely manner, and where long-term storage at a facility is discouraged. We don't want these sitting at places where potential harm could happen. Exemption does provide alternative standards for auto dealers and other entities, but it does not change their obligation to safely manage and dispose of the airbag waste. The new rule will be found at 6 CCR 1007-3 261.4J for airbag waste, provided that the airbag handler sends the airbag waste either to a RCRA designated facility or to a designated airbag collection facility. And there are also some conditions for exemption that we'll go over here in a little bit. The conditions of exemption were based on EPA's kind of study of industry practices, ensuring that these exempted airbags will be managed safely and not diverted back into the auto industry. And bear in mind, I didn't go over this at the beginning, but this rule was, an interim final rule was implemented by EPA at the end of November of 2018. This rule is less stringent, so we are not required to adopt it, but in the manner in which this rule is being implemented, the division believes it's the best. It's the best for us to follow this to help get rid of the recalled airbags. So what are the conditions for exemptions for the airbag waste handler, which typically would be an auto dealership? They can only have 250 airbag modules or air inflators at one time. They cannot store these for more than 180 days. And they need to package and ship in a container that basically will allow safe transportation, probably based on DOT regulations. They must be labeled airbag waste, do not reuse, and they will have to maintain shipping records and confirmation of receipt for 3 years. Once the recalled airbags make it to a TSD RCRA designated facility or to a designated airbag collection facility, they then become the record generator. It's now, this exemption basically goes away. It is now a regulated hazardous waste. There is a new sham recycling is already in our regulations. Therefore, the reuse of recalled defective airbags would be considered sham recycling, and that would be a violation for anybody that would do this. And just to reiterate that this is just not for Takata airbags, it is also for any recalled airbags that will be allowed to use this exemption. Any questions? I think you guys burned yourself out on Ed's. I'm hoping anyway.
What kind of final ultimate disposal do these airbags?
Well, they would have to meet the LDR requirements for either ignitability or the reactivity. So incineration for reactive waste typically would not occur. So they'd have to meet whatever land disposal restriction there is for the recalled airbag, and that would be reactivity. So they would probably be safely basically blown up to get rid of that characteristic. And then potentially they could be incinerated to get rid of the ignitability factor.
So is there a record of some of them blowing up in transit? I mean,
I think there's a potential for that because, and remember, this happens more in like the southern states with high humidity where the degradation occurs more quickly, but I haven't heard of anything in the transport. But I think this to ensure safety of all individuals involved, they want to make sure that the containers are appropriately able to withstand, an explosion if it did occur. But once they did get to the TSD, it would be up to them to make sure that they're disposed of correctly based on their waste profile and land disposal restriction.
Can you briefly tell us in what way this is less stringent?
So normally, because they do not get the reuse or reclamation exclusion because it would be sham recycling if they tried to reuse it. They're not able to safely deploy the mechanism unless you're permitted to do it. They would have to be managed as a haz waste. So that means every Ford dealership that's recalling all these Takatas would have, depending on how many they're pulling out of their vehicles, would have to manage all that as a hazardous waste. Depending on their numbers, they could become small quantity generators, large quantity generators, with all the requirements based on how much of these they generate. Because typically, most dealerships, if they have an auto body, they might be a very small quantity generator based on waste generated in the paint booth from lacquer thinner, stuff like that. Some have parts washers, but typically they're only generating used oil, if that. So they're typically not generating hazardous waste. Therefore, we bring them into the higher category. Like I said, I think they just want to really ensure that to impose less regulation, that people are not going to skirt this requirement and this lesser requirement for the, storing up to 250 days. It's not affecting their generator category. They can store it for 6 months, which is a pretty good time to be able to store it. So I think that's the key is to reduce the regulation, reduce the cost for a facility, and therefore they're not going to try to skirt getting rid of the recall.
Is that pretty consistent management of the issue with other states in our region?
I would think so, because this is almost like a federal EPA emergency rule that they implemented.
Mm-hmm.
Like I said, it is less stringent. I haven't checked with other states to see if have authorized the rule yet. But states that like Iowa, certain ones that don't have their own program, this is already in place. And there were comments up to the end of January of 2019. And I think EPA is looking at like 180-day comment period, because typically rules are an extended comment period. So at the end of that 180 days, we'll kind of look and see if there's been any issues. I haven't heard of anything with the regulated community. Typically, we don't inspect these type of facilities because they are very small quantity generators and are not generators of hazardous waste unless we would get a complaint. Is kind of the only reason we would inspect them. Maybe once this goes into effect, we might just stop in to see if this is being carried out appropriately at any of the auto dealerships throughout the state.
So maybe I missed it, but is there some way for a non-generator currently that's going to be part of this program to register with the division?
They won't, because it's not changing their generator category. It won't be required for them to notify with us. But now with like the new e-manifest rule, stuff like that, depends on who's going to transport the waste for them. Mm-hmm. If they're going to use it doesn't specify the use of a notified RIC or transporter, because it's kind of excluded, not considered a traditional haz waste. But normally with the new e-manifest, transporters are requiring almost all facilities to get an EPID number just for tracking purposes with the e-manifest, even though it's not a requirement with this.
Got it. Thank you.
Mm-hmm.
So this rule applies to recalled airbag waste.
Correct.
This shows my ignorance, but unrecalled airbag waste, is there such a thing? And if so, how is it handled?
It can be handled in a variety of ways. It can be considered a scrap metal, so therefore it's excluded from haz waste management. So it might be in a car at a junkyard. It's excluded when they take the scrap metal out. Their liability will not be there for the airbag. There's also ways where, like wreck cars where it hasn't been deployed, they're able to recirculate those back into the auto industry and reuse like the modulators and the inflators back into cars that are being built. So that's the RCRA exclusions and exemptions that aren't allowed for the recalled airbags, because do not want those to be back into the system.
Right. So there aren't similar safety concerns with a airbag
No.
that has not been recalled. Okay, thank you.
So if nobody else has anything, I'm just gonna make a couple.
I have a question. So the 250 accumulation and the 180 days, is that taken directly from EPA? That's
That
not
is.
something we
This
came up with?
rule, the definitions, the requirements or the conditions for exemption we didn't make any changes. It's taken directly from EPA's interim final rule published in November of 2018.
And the collected airbags are being transported out of state to be safely disposed of?
I don't know if they're out of state. I haven't seen that we have any of the facilities that are allowed to take airbag waste. I imagine these are more towards industries that manufacture them. They could be going to TSDs, maybe potentially Clean Harbors, Deer Trail. I don't know for sure. I haven't seen any of these on inspection, so I haven't been able to track where these are going. I haven't heard of any of the designated airbag waste handling facilities being implemented in Colorado. So to my knowledge, most of them are going out of state to these type of industries.
And you were saying that most of the facilities that are accumulating these are auto dealerships are not in regular contact with your department because they are very small quantity generators. How will they be notified of this rule?
I think just through industry networking, they want to make sure that they're doing it properly and the cheapest manner that they can do it. And I think through trade shows, et cetera, they've been dealing with this and know that there has waste now that this exemption will be introduced in the state. I don't know specifically how we would get the information out to auto dealers. They know about, I'm assuming at the corporate levels, Ford, all those are aware of this new rule at the federal level and know that it will be implemented throughout states kind of at various times.
And is there any financial impact
Not that I'm aware of.
changing this rule?
I don't think so. I mean, I think it actually should, like I said, it's beneficial that they don't have to manage these as a hazardous waste. They don't have to train it, do the SQG requirements, LQG requirements, which typically there's some financial hardship, not hardship, but the requirements for increasing your generator category status.
So this is likely to either not impact or reduce the financial burden.
Mhm.
And any other question? Jennifer?
So I have two things for you and then I have one thing for you. I know you got this from the EPA rule, but one of the questions I had in J1, it lists like all the requirements that would make you exempt from Part 99, and they're all separated by a semicolon, but there's never an and or an or. And so I'm wondering if you have to do all 1 through 5 or 1 through 5. And I looked at the EPA rule and it's not in there. So I think it's an error in their part, and I think
Right.
that we can fix it in ours.
Not great at wordsmithing if you think.
It's
that's
really
a-
just whether it's
And,
really at the
and,
end of number 4 before number 5, if it should be an and. If you need to meet all of those requirements, then it should be an and there.
Yeah. Yep.
And so I think that would make it clear for the person,
Mhm.
a person reading this rule to know that they need to do all of those things. Okay, so that was and then you talked about it being less stringent. What is it less stringent then? Like EPA has this interim final rule, but it looks like you copied that.
We did, but
rule. So
the
is
whole
it
rule
same?
as a whole is less stringent because normally they would have to manage any recalled airbag waste as a traditional.
Right, but it's not less stringent than the EPA rule.
It's less stringent.
Equivalent to.
It's equivalent to their rule, but less stringent than anything we have right now.
Okay,
Does that make sense?
right, okay. So for the commission, you're just going to adopt the rule as you would adopt any other rule because it's not more stringent than anything else. And then also for the commission in lowercase I, 4, it references a federal regulation that's being incorporated by reference. So when the final rule gets submitted to the Colorado Register, Randy will make some changes to that language that meet our Colorado state requirements for when we incorporate federal regulations by reference. And when you adopt the rule, you'll need to reference that we will do that. Thanks. I don't have anything else.
Any further questions for staff?
Where's number 4?
So it's that one right on where this 49 CFR.
Oh, okay.
That's a
Little
federal
ID. Okay.
registration reference.
Thank
that's
you.
being incorporated into our state.
Okay.
Any public comment? No blue cards? No? Okay. So I'll close the record and open it to Commissioner deliberation. Wow. It seems like this is maintaining safety and also looking out for the well-being of some of the businesses that would be negatively impacted if we did not adopt this rule, is what I'm seeing. And that's my only comment on it. Would anyone like to make a motion? Jennifer has scared us off.
I'll make a motion. I'll make a shot at it. I move that we adopt the proposed rules regarding amendment to 6 CCR 1007-3, Part 6, regulations pertaining to hazardous waste and solid and hazardous waste commission. Oh, wrong one. Sorry. I didn't put a check mark next to that. We'll start over. I move that we adopt the proposed rules regarding the amendment to 6 CCR 1007-3, Part 260s, 261, and 262, regulations pertaining to hazardous waste, safe management of recalled airbags, and the accompanying statement of basis and purpose, with one change that we need to note that when this gets put into the translated, Randy will make a modification to line 67 and 68 to indicate that a federal regulation is being quoted. That, right?
And the word and.
And the word and instead of and or. Replace or with and.
No, just add the word and.
Add the word and.
Which line?
On line 68.
68, so that that's included, so that all 5 of those items need to be.
Second.
Motion made and seconded. All in favor?
Aye.
All opposed? The motion carries unanimously. Thank you.
Randy? My battery is dead.
We can,
Okay. So that allows us to move on to the next rulemaking hearing, where we'll be discussing amendment to 6 CCR 1007-3, Part 262, Subpart L, regulations pertaining to hazardous waste, episodic generation requirements.
all right, so you guys get me again for this proposed rulemaking. I'm going to start off by we didn't really have an informational on this in February. This goes back to the new generator rule in July. Us as a state decided not to adopt the entire Subpart L episodic generation regulations straight across from the federal regulations. We decided to kind of keep what we have in place, where facility jumps up in generator category to BSQG to a SQG or LQG, or an SQG or an LQG, that they're required to follow those requirements throughout that episodic period. We did implement that if they only had one of these events in a year, they would be exempt from biennial reporting in an odd even year. Basically meaning for 2019, if they had one episodic event, they did not have to biennial report in 2020. If they had 2, then they would have to biennial report and still follow all the regulations for the month that they were in that generator category. I looked at some numbers for the types of generator status changes we've had as a state since the new generator rule went into effect. There's basically 2 types that we track. They're what are called short-term generators, which is a facility that typically never generates hazardous waste, and then they have a one-time incident where they generate hazardous waste. It could be because of some sort of a spill, or somebody that acquires a building that has hazardous waste on site. It wasn't theirs, but now they have to get rid of it. A short-term generator is not the same as an episodic generator, what we're talking about today. So a short-term generator, they are required to follow all the regulations for the month that they're a short-term generator, including biennial reporting. There is no exemption from that for short-term generators. So since July of 2018, we've had 19 short-term large quantity generators notify with us as a division, and 28 short-term SQG generators, meaning they had to follow the regulations for that month. The large quantity generators, if they were short-term in 2019, they will have to biannual report for 2020. Episodic generation, since July of last year, we've had 30 episodic large quantity generators and 9 episodic small quantity generators. So these are kind of the facilities that we're talking about today. These are facilities that typically generate hazardous waste at either a very small quantity generator level or small quantity generator level, and then have some sort of, and we'll talk about it, a planned or unplanned event where they increase their haz waste generation for a month and then therefore are required to follow certain requirements. Like I said, we decided in July that if they did this, that they would have to follow all the requirements of the generator category that they were in, meaning either an LQG or SQG. And if they only had one event in an odd year, like I said, they'd biannual report in the even year. There's been some confusion, I think a little bit of confusion in regards to how we're different from the feds regulations regarding that. At the federal level, there are requirements that if you have an episodic event, you're only allowed to store it on site for 60 days. Whereas a small quantity generator would get 180, an LQG would get 90. So kind of some confusion maybe for the regulated industry based on that. Also, we got rid of our own Colorado hazardous waste notification forms and went to the standard EPA forms, basically for paperwork reduction, to allow them to, I think we talked about this, allow them to change notification electronically, not using the paper copies. However, on that notification form for episodic events, there are word or statements that are not defined in our regulations for like a planned episodic event, unplanned episodic event. So today we're just kind of going through adding some clarifications, some definitions to kind of make this rule more clear and transparent to the regulated industry. So I guess kind of get going with it. So the reason for these amendments to subpart L, like I said, are to provide additional definitions for episodic events, provide equivalency with federal notification, labeling, duration, and record keeping requirements, clarify the VSQG or SQG requirements for maintaining the generator category during an episodic event, and clarifying the exemption from biannual reporting if they bump up to an LQG during an episodic event. So first off, we have definitions for episodic event, planned episodic event, and unplanned episodic event. And these are needed because they're referenced in requirements for facilities during an episodic event, and also they are used within the notification forms. An episodic event is an activity or activities either planned or unplanned that does not normally occur during generator operations, resulting in an increase in the generation of hazardous waste that exceeds a calendar month limit for the generator's usual category. Once again, a VSQG generating as an SQG or an LQG, an SQG generating an LQG during this event. A planned episodic event could be regular maintenance, tank cleanout, a short-term project, or typically we see these a lot are lab cleanouts at universities where they're going from an SQG to an LQG. It's pretty common. Planned episodic events are fairly common for facilities that we do inspect. An unplanned episodic event, typically this is from some sort of increase in production. They're now generating more waste than they thought they were going to generate, product recalls, spills, and active nature. So these are events that are unforeseen. It happens at a facility. You'll see how they have to respond based on what happens during an unplanned episodic event. Secondly, we're going to provide equivalency with the federal episodic subpart L requirements for notification, labeling, duration for storage, and record keeping requirements. What are the notification requirements? For a planned episodic event, facility should notify the division 30 days prior to initiating a planned episodic event. Obviously, with an unplanned episodic event, the facility didn't know what was going to happen. The requirement is that they notify the department within 72 hours of an unplanned episodic event. Labeling requirements that go above and beyond normal hazardous waste labeling. Basically, this has to say episodic hazardous waste. And it will, that's basically to keep it, because the duration, you'll see in the next slide, is different. This way they'll have to kind of separate their episodic waste from their normal waste, because there'll be different time frames for storage based on the episodic event that occurred. That duration will be, doesn't matter if you're VSQG or SQG bumping up to VSQG and SQG or an LQG, the duration will stay the same. It is 60 days from the start of the episodic event. And it has to be manifested and sent to a designated haz waste facility. What happens if a facility stores for greater than 60 days? They lose that generator flexibility, and now they are considered the category that they're at, and therefore would lose that exemption for biannual reporting if they store it for greater than 60 days. Record keeping requirements must be maintained on site for 3 years. The beginning and end of the episodic event, what was the episodic event, types and quantities of hazardous waste generated during the event, where did the haz waste go to, and who was used to transport this hazardous waste. So these are typical timeframes for manifest retention, land disposal restriction retention. So kind of match up with that for the episodic event. So we wanted to provide further clarification for generator category, kind of lessen the confusion. So basically, VSQG or SQG that is experiencing an episodic event need to comply with all the categories that they bumped up into either an SQG or an LQG. And if they do that, they will be exempt from the biannual reporting requirements if it's one unplanned or one planned event in a calendar year. And this kind of goes into more detail regarding that. However, it talks about one calendar year, you're allowed an unplanned or planned event, and you maintain the biannual reporting exemption. On the second paragraph, if you generate episodically more than once per calendar year, you must comply with all the LQG requirements of Part 262, including biannual reporting, and then these new additional requirements, the notification, labeling, duration, and record keeping requirements that are specific to episodic generation only. And that's it.
Question about the generators who have an episodic event, either planned or unplanned, more than once a year. I understand what that means in terms of their reporting requirements and how they handle waste for that year. Do they have the ability then to jump back down at some point, or do they maintain that new category from now on?
No, because it's episodic, they maintain that. I guess it's almost like an exemption from that category, unless they exceed the generator amounts more than 4 times in a year. Then you are required to notify as the higher generated category. So either an SQG or an LQG based on the amount of haz waste you generated in those 4 months. So that is a requirement, and then they would be billed at that level. So basically 1 through 3, you could do the episodic event. The first one, if you bump up to an LQG, you get that exemption from biannual reporting. However, if you do 2 to 3 times in a calendar year, you lose that exemption for biannual reporting, and you have to follow all the regulations based on whatever category you're in for that month or episode, the episodic event.
I guess I have a couple of observations. First, I do commend you for looking at not having to do a biennial report, because I think that's pretty onerous for someone that's
Yeah, because that's,
done it for a month. But I think there's two things I'd be concerned about. Coming from someone that had, several facilities,
Mhm.
a large quantity, and several conditionally exempt, or now called very small quantity generators. I think some of the difficulty is actually standing up a training program and getting people trained. And so like I used to at our facilities just have everybody trained, because I was always worried that we would have an episode, and to have a month to stand up training. And we had 3,000 employees that had interactions with those conditionally exempt facilities. And so that worries me a little bit, because I think training can be just as onerous as biannual. And I don't know if there's some abbreviated version of that. And the only other thing that I'd be concerned about is I think that in some cases people may, and this is true from going out and doing inspections in my day too, in looking at some of this, people may postpone doing maintenance activities or doing other things and storing things as hazardous materials that aren't really necessarily declared as waste yet. And they may delay doing something because they've already used their one-time kind of pass. And so then we end up with things that may have, should be getting rid of them, and they keep them longer than they should, just so that they're able to take this exemption like every other year or every year or something. So I would just worry sometimes that this could create that kind of a pathway for some people, that they would have things on site longer than they should.
Sure. And just going back to like the episodic events where it exempts them from biennial reporting, there's only been, out of the 30 episodic events since July of last year, there's only been 2 facilities that have had 2 separate episodic events that may require them to biennial report now. So
2 that let you know that.
2 that let us know, you're right. And this is,
Because I think especially in a university or laboratory environment, or like for me in the aerospace industry, a program ends and a new one starts. And a lot of times you're getting rid of all the stuff from that program because the government didn't make it easy to use it on other programs. So there's those kinds of transitional environments, as opposed to people that kind of have the same process and it's very steady and they use the same materials. It's more the ones in the pharmaceutical, aerospace, some of those other industries where they're constantly shifting around the materials that they're using. And so, and again, there's not necessarily a way to nail any of that down. It's just being said more as a observational thing that we should consider.
and you're right. It's, if somebody wanted to skirt these regulations, the only way we would find out is on an inspection. If somehow we, during manifest reviews, are able to see that, they normally are shipping 4 drums every 3 months and then they ship 15. Well, why did that happen? And then kind of going back to, you were talking about training and stuff. And basically, since I've been an inspector, like the planned events, seems like, it's easy for folks to have the training in place, all that type of stuff. Obviously, having an unplanned event, you go back and look and, well, now I'm an LQG, I need to have training, a contingency plan, all that type of stuff. And what we've always done as a unit is basically work with those facilities to say, well, here's a contingency plan template that you can put together in 30 minutes. Here's some training stuff that if you're an SQG and LQG, that you could, I understand if you have 3,000 people, that's kind of crazy. If you have 3,000 people, they're already a large quantity generator. You know what I mean? It's, I understand where that can be hard, but we really do our best to work with facilities to ensure that they're obviously they're going to be out of compliance the second that event happens, right? But we would follow enforcement discretion and ensure that they're doing the right things to come into compliance before we would hit them with a heavy hammer or anything like that. So that's always been the path that we've followed before, and that we'll still continue to follow based on unplanned events. Like I said, it would just be a very rare occurrence for us to show up unless there was a complaint, maybe where somebody said, well, this facility had a humongous spill, they're trying to hide it or something. Typically on our planned inspections for large quantity generators, they're not bumping up. So we're not going to see a lot of these facilities unless they are complaints or they are small quantity generators that are part of our self-serve program, where we would potentially see an episodic event at a facility.
Just to add on to that, having been somebody who got to go through this numerous times with acquisitions and divestitures.
Mhm.
It's something, I don't know if you have the data or you see it, but they don't normally occur in a 30-day clean
Right,
window.
right.
So I don't know how you adjust to that, or if it's something you're.
Well, we could look at it as the duration of the event is, I know it's it could spill from 1st of March until the end of April. We'd look at that as one event. And as long as you got rid of that waste when it's generated within the 60-day window, then you maintain basically your generator category that you're at. But during that time frame, you need to manage that waste as if it were small coin generator or large coin generator waste. Does that make sense?
Yep.
Okay.
Just letting you know, it's hard to do.
Oh, I know. Well, I mean, that's kind of why we went away from the following exactly the federal rule, because we felt like that was more complex.
This is an improvement, no doubt.
Yeah. And like I said, like with the EPA rule, they do get it out of binary reporting for 2 events in a calendar year, but it has to go planned, unplanned, or unplanned, planned. They can't have 2 planned events, then they have to binary report for everything. Or if they have 2 unplanned, that's where we were getting into the minutia. It was getting confusing. That's why we kind of initially went to just the way we've done it in the past, and now trying to clarify some of these confusion for industry with these changes here.
And just one question. I thought I heard you say during the presentation that episodic materials have to be stored separately from.
Well, the way I would look, it doesn't say that. It has to be labeled separately, and it has a different time frame than normal. Well, VSQG waste has no time frame. SQG is typically 180, and then LQG 90. I guess when I've gone on inspections and they had an event, I'd be like, well, how are you able to track it? It seems like they'd have to separate out, unless they had a good tracking system, I guess. It's not a requirement. It's just how
Sometimes folks have
Right.
have the storage area they have.
Right.
So you mentioned that only 2 repeated. So basically what you're seeing with these episodic events is you're not seeing the situation Laura was describing where people are trying to game the system, as it were, to get the exception.
I mean, I'll be honest. I know there's facilities that they plan their cleanouts to do it on an even number of years, just so in the past they didn't have to buy on a report. But to me, that's not skirting the regulations. That's just kind of smart business management. It's saving them a ton of money on consulting costs, doing all that type of stuff. And we don't regulate anything until it's away. So if they hold off on a tank cleanout, they're not out of compliance for doing that. They're still operating that as a normal part of their manufacturing or storage process, that it is a product. It's just now they kind of changed their maintenance schedules, like Laura said, to basically I think a lot of it's just for financial reasons, that they don't have to hire a consultant in the past to do a binary report. Because, it's not just the 1 month that they have to report for when they binary report. It's the entire year of hazardous waste generation. So, and now I think with this rule, it allows them to have a planned event in a binary reporting year without having to worry about maybe waiting until 2020 to do this maintenance operation, as long as it's a planned event. Obviously, if something happens and they have an unplanned event later in the year, that strategy went out the window. Now they have to report for the whole year. But that's kind of where it's at. So,
David, question. I think you guys received comments from the city of Aurora.
We did.
I didn't see any changes to the language post comments. So,
yeah, we made.
Sorry, I guess
we kind of reorganized a little bit under. I don't know if you have the
May 15th draft.
Yeah, we
Yellow
received
highlight.
2 versions of
okay.
this rule.
Sorry, I have May 21.
So that
incorporates
that has the changes that we made after City of Aurora's comment. So we kind of reorganized under 262.232, changed some wording that could be kind of construed as a little bit confusing. and kind of organize it better to show that no matter what category you bump into, if you're a VSQG that goes to an SQG or a VSQG or SQG that bumps to an LQG, the notification, labeling, duration, and record keeping are a requirement no matter what category you bump up into. And that, it looked a little weird in the way we had it the first.
Okay.
You didn't really change the content.
No, we
Just
kind of move stuff
reorder.
around, try to make it easier, less complex, just basically. So
And that
it
was
flows
in
better.
response to their,
Correct. Yep.
Yeah, and sorry, I think that was more of my point. It got shuffled, but I didn't see any content change.
And we, the Hazardous program manager, Doug Knapp, provided a response to City of Aurora. Did you guys receive that also? Kind of outlining that we appreciated their comments, thought they were good. Some of their, it was a little confusing on the stuff that they had proposed. And like I said, that's why we kind of moved stuff around so it flowed better based on their comments about confusion. They wanted to add more than just the notification, duration, labeling, and record keeping. They wanted to add in some stuff for training, inspections, and contingency and emergency procedures that we feel was already, when you bump up to an SQG or an LQG, those are already in the regulations for a facility to follow. So that's why we did not incorporate those.
so the notification, labeling, and duration are different for this exception.
They, for an episodic,
For an
yes,
episodic
to-
event, that's different.
to maintain that generator category kind of exemption where you're not basically the biennial report exemption, you have to follow those requirements for notification, labeling, duration, and record keeping to
And the-
maintain your
To
basically
maintain the
generator.
exception.
Right.
And the training, inspections, and contingency plans, there is no change from what's already in the rules for those.
Those are already, when they
categories.
bump, because when they bump up, they have to follow the requirements of either a small coin generator or a large coin generator. And that's how we've always had it. And that's how we changed it in June of last year. And when they do bump up into those categories, I mean, it is confusing because you're maintaining the lower category, but you have to follow these requirements while you're in that episodic event, right? So within that, those regulations for an SQG or an LQG, there are specific training requirements, inspections, and contingency plans. And this was going back to Laura, where for an unplanned event or even a planned event, we work with those facilities to supply. They need a template for a contingency plan. If they need, what do they need to train their folks on? We provide that for facilities, either based on a planned or unplanned event. So they are in compliance with those higher level requirements.
The department did make changes based on Aurora's comments. They just didn't make all the changes that they suggested because they felt that it would be more confusing. Because as I'm understanding it, what you're calling out in this new rule are the things that are different from what's already written in the regulations.
Right, right.
And if you included stuff that was the same, that might be confusing.
Right, right. Yeah, like I said, there are some things that are different, like the labeling duration. But training, inspections, contingency plan, those are all, or emergency preparedness are already specified by SQG or LQG. And then, like I said, the notification, labeling, duration, and record keeping are basically straight from EPA subpart L. And so that's kind of how we align with some of the EPA stuff, but not all of it.
And I know that you guys encourage people who are close to the next category to just go ahead and comply with the next category.
Yeah, we
just
call
in
it
case.
like BMPs, best management practices. You know, if you have a tendency to bump up in the categories and drop down, we recommend that they just follow those practices for an SQG or an LQG because there's potential for them to bump into that category. And that way they're prepared and will be in compliance with the regulations when they do have a surge of hazardous waste generation.
Do you feel that by making these exemptions more accessible, that will encourage people to not do that? Because they feel like the worst that could happen is we'll do it 4 times. And so we're just going to maintain.
I don't know for sure. I don't think, like I said, like going back to Laura, there could be 400 VSQGs that we've never inspected, don't know anything about, that are bumping up every month or 4 times a year, but we're never going to find out for those type of generators unless we go there on a complaint or they're in an industry that we do self-certification with. There's just, the numbers are too high for very small quantity generators that we don't know about. There's really no way to find out every generator in the state of Colorado. So it's, if they don't know what category, if they don't know to notify at a certain level, there's no way they're going to notify as an episodic, basically, is kind of what Laura was saying.
Yes.
David, can you tell me, besides, did you do any stakeholder outreach besides just the notice of proposed rulemaking on this
No,
requirement?
we didn't.
Okay.
Because we felt like we weren't really making any significant changes and there's no, they're already required to manage their facility at the higher requirements when they bump up. So these, the notification, labeling, duration, and record keeping aren't
all
really
providing
requirements that are above and beyond what they were already required to do.
Providing regulatory relief is what you're saying? Yeah.
In a way, yeah.
Okay. Thank you.
And since you made the changes, has the city of Aurora, they were notified of the changes and did they respond to that?
No, but I think they're here, the representatives here, so.
Aha. Okay. Any other questions for staff? Any other comments from staff?
I just have one on line 80. There's a semicolon there, but I think it should be a period.
Could you repeat that?
On line 80, there's a semicolon at the end of the sentence, but I think it should be a period to be consistent with the ends of line 83, line 87, and line 97. It's just inconsistent with how it's proposed.
David, is that,
Yeah.
would that change the meaning of
Yeah,
that in
sorry, I
any
was trying to, I
substantial
have a
way?
different, I have the one that we changed, so I can't really see where it's at, but I think that's fine.
I think she
It's
has.
the
it
end
there.
of, it's just the end of paragraph C1.
No, that's fine. Wait, Randy?
Yep, yeah, I got it.
Okay. No further questions? Then it is time to invite the public to comment. You said someone was here
I
that
thought-
might want to comment?
Yeah, I don't know.
I'm with City of Corona. I don't necessarily comment. I did send a response to Brandy late last night that we were okay with the proposed changes that they had come up with, so.
Okay.
Okay, so what I'm hearing is the city of Aurora has sent an email to the commission that says you're okay with the most recent version that incorporated many of your suggestions. All right, so we will close the record and open it up for commissioner deliberation.
So just while you're deliberating, just a note that this is more stringent when you're making your motion.
So she didn't turn it on all the way. Was off. So it looks like line 80, 83, and 87 should be possibly semicolons with an and. At 87, isn't it 1, 2, 3, and 4 apply? Or is it periods, as you say?
So I went off of how it's written on line 57 because it says, and must comply with the additional conditions of paragraphs C1 through C4 of this section. So it's already implying that it's all of them.
So it's
From
covered
that.
there, okay.
So it can't, you could do semicolons and then say and. That just required more changes. And I was trying to
Yeah, no, I get it.
be simpler. But either way that the commission prefers it is fine.
Does anyone else think that that semicolon and an and is preferable to what's on line 62, where it says and must comply with the additional conditions of paragraph C1 through C4? Everybody.
Simpler is better.
No discussion? And is there a motion on the table?
I'll give it a try. I move that we adopt the proposed rules regarding amendment to 6 CCR 1007-3, Part 262, Subpart L, regulations pertaining to hazardous waste episodic generation requirements, the May 15th, 2019 revised draft with an amendment to line 80 that changes replaces the semicolon with a period. Along with the statement of basis of purpose and the finding herein that the rule is necessary to protect the public health and environment of the state.
Second.
Motion has been made and seconded. All in favor?
Aye.
All opposed? The motion carries. Thank you, David. And we have 20 minutes before the lunch break, and we have some updates. Do we have an update that would squeeze into 20 minutes?
Yes, absolutely.
Let's do it.
Would it be possible for you to bring up the department? I'm sorry I didn't ask ahead of time. So while Brandy is fulfilling a request for me to bring up the department org chart, just so I can give you updates on where we are with that, I'll give you updates on where we are with the division org chart, which I think I told most of you who were here at the last meeting that unfortunately, despite my begging and pleading, coercing, Joe Shefflin is intending to leave us at the end of June. We are planning a party for him. I sent the invitation to Brandy. I hope she was able to forward it. Yes, it is going to be on July the 20th, June 20th. See, I'm still working on extending it. June 20th. It's going to be at Choppers. Please feel free to circulate it to anybody who you think wants to come. I would just ask for an RSVP to me. It's at 4:00 in the afternoon. An RSVP to me or to Brandy, who could forward it to me, so that we can just make sure we have enough food. So, because I'm sure it's going to be a huge party, and we're going to make Joe talk, and it's going to be great. So we are recruiting for Joe's replacement. We have 4 candidates, 3 of whom are internal and 1 external, and we'll be interviewing them on Thursday with the hope that we can get someone in with a week or 2 of overlap before Joe leaves, but knock on wood on that. So the other update I have kind of on our internal org chart is that we've been without a community involvement manager for a while. And so we did interviews for that position. And, you know, that position just kind of does our communication stuff plus our community involvement stuff, and our helps us with stakeholder outreach, and runs a small community involvement unit that we have. We did interviews for that position yesterday, had 6 really good candidates, and are hoping to make an offer for that position in the next couple of weeks. On the overall department org chart, you'll see that, you know, Jill Ryan was here at the last meeting. She's our new executive director, and she has just replaced Martha Rudolph with John Putnam as the head of environmental programs and my direct boss. So I'm down here under air and sustainability, and then us. So John comes to us from, he's an attorney. He's an environmental attorney with a lot of experience in air quality issues, but he also has worked on some issues that impact the division, including some CERCLA and RCRA stuff. So I think he's going to be really good, and we're working on briefing him as well as Jill on any concerns or issues that they have. So we're working on that. That's all I had on that, unless anybody has any questions on that. All right.
I have a question.
Yes.
Any redirect as a result of the change of governor administration?
I wouldn't say redirect right now. There are a couple of issues that Rocky Flats being one of them that we kind of thought were put to bed that are kind of being looked at again, just for information purposes, I think, for the new administration. So, but no real redirect and not too many issues that impact this group with the exception of a couple. But a lot of stuff kind of on our surplus cleanup side and a couple of things in Doug's program. So, and maybe one in Joe's, but anyway, it's been okay. It's mostly been briefing and just making sure that they understand where we're coming from on issues that are being brought to them from outsiders. So, I wanted to give you an update on T-norm because I want to keep this on your radar because I think it's going to end up impacting you with a potential rulemaking next year. So I think we talked about before that T-norm is technologically enhanced naturally occurring radioactive material. It's when you process some kind of a natural resource and you end up concentrating the naturally occurring radionuclides in it. Most often this impacts oil and gas and water treatment and wastewater treatment, drinking water treatment and wastewater treatment entities. And as we've talked about before, we did get authority to promulgate rules. The department received authority to promulgate rules actually through the Board of Health on the regulation of T-norm. So those will come through our radiation side to the Board of Health. But then we may need to do some adjustments on the solid waste side, depending on if we end up in a situation where, which we think is a good outcome, which is some of these low-level materials to be disposed of as solid waste and not necessarily radioactive waste. So what the bill that passed last year required was for us to do a report. And we hired a contractor to do that report. And the report talks about like background and what other states are doing, background radiation levels, what other states are doing, kind of analyzes which industries are generating this material. And so we hired a contractor to do that report. And that report was finalized we got a draft in March and we sent it out to stakeholders for comment. We received about 20 comments, 20 commenter letters with a lot of other comments. And we're working through those with the contractor now, and we expect to have the final report out on the street the beginning of, probably around June 7th. The next step will be to reopen our stakeholder process on kind of the beginning of regulatory development. And so the reason why I'm bringing this to your, just again, to keep it on your radar, because we might end up having to come to you guys with some rulemaking next year. And then we also, you might start to hear things from certain entities like the oil and gas and wastewater and drinking water and even landfill operators regarding this issue. There was a big push from some landfill operators that they would prefer the rulemaking, when we were working on the legislation, that they would have preferred the rulemaking to come through you guys. But we think that actually, the primary part of the rulemaking will be to establish standards for what materials can be disposed of where, and that's done on a radiation risk exposure type of a decision making, and that really lives with the Board of Health and the radiation regs. So that's where we are with T-norm. Any questions on that? All right, as we get closer, yes, Catherine.
How long do you expect the public comment period to go on for?
So the next stakeholder process will go for hopefully we're going to start it at the end of June, and it will probably go through November. And then we're because we have a lot of meetings we need to have with stakeholders regarding how we assess the risk of these materials and how we determine where they can safely be disposed of. And so, and or used beneficially for a beneficial reuse, like a biosolid. And so we have a lot of meetings we need to have. And we're trying not to bump them too close together. So we are required at the end of this year to provide a report to the state legislature on both the TNORM report and on the stakeholder process. And so that's kind of our deadline for this next stakeholder process. And then we'll go into regulatory rule development work, which will provide another public comment stakeholder process. And that'll happen next year.
Thank you.
Sure. So yeah, as we get closer to trying to determine what those regs are going to look like early next year, hopefully we'll be providing you guys with some informational briefings on that. So, and that's all I had. Do you have any questions for me? All right, thank you.
All right. The legislative update, do we have time for that?
How long are you?
10 minutes.
10 minutes?
Let me at least, I'll do at least some of it. Tell me when to shut.
Is anyone starving?
Well, I was gonna say the longer you can, like, if we can complete this portion, then we can end our YouTube broadcast before we move into our training sessions. So if we complete the business portion.
Continue.
I think Brian Gaborio's, David is texting him now to come back down and join me, just in case you have questions that I can answer, but I can certainly get started on. I need to tell you about two things legislatively. Two bills passed and one bill did not, that I want to talk to you a little bit about. The first bill that passed that is definitely going to implement or impact you and the commission as the commission is Senate Bill 19-198, which has to do with waste tires. Just a few key points in that bill. The current 55 cents per tire fee that is charged now whenever you buy a new tire at a retailer will remain in effect until December 31st of this year. But the bill reestablishes the end user program that was repealed at the end of 2018, and it will start again on January 1st of 2020. So at that point, the commission, by the January 1 of 2020, you all as the commission will have to approve the new waste tire fee that will then be assessed starting on January 1, 2020. The statute caps that fee at $2. If you remember back at the end of 2018, when it sunsetted, it was at $1.50. That's where you had set it at that time. So the statute caps it at $2, so you can have it anywhere between, I guess where it is now, 55 cents and $2. And we're going to be giving you a lot of information on how to set that fee. So we won't be doing that in a vacuum. The funds from the approved waste tire fee will be distributed so whatever the fee is that's charged will be distributed between two different funds. One is the administrative fund, which is the full title of it is the Waste Tire Administration, Enforcement, Market Development, and Cleanup Fund. And then the other fund is the end user fund, the end user rebate fund. So right now, the 55 cents that is being charged is coming into only the administration fund. And we use that to not only pay our staff salaries, but we also use it to clean up the illegal tire piles that we know of around the state. We just recently cleaned up our millionth tire since that program was transferred over to the health department from DORA back 10 years ago or so. So we've been doing that a lot, and Brian has been working very diligently in the last year, particularly since we haven't been doing end user rebates on getting those tire piles cleaned up, but there's still some more of that to do. But at the end of the day, I think that we're going to be able to recommend to you that our portion of the fee probably stays lower than it is now, probably around 50 cents per tire, because we're going to be able to do, we think, all of those things for about 50 cents a tire. The one addition that we are glad to see in the bill is that our portion of that money that goes into the admin fee will now be able to be used for market development. We had kind of lost that ability over the last several years. We've still been having our annual waste tire conference where a lot of states and a lot of companies come, and it's been a very well received and nationally recognized conference that we host every year. We've been doing that on our own, using just our own money, but now we'll be able to officially do those kind of things, as well as maybe even support some innovative tire reuse technologies and or businesses that might want to relocate to Colorado. A couple other highlights I want to mention. The end users in the past, if you remember, we only set one end user rebate. What this bill allows us to do is to set three. It tiers the rebates. And I don't know if you remember this, but we had a lot of conversations in the commission about the relative quality of different things that people do with end uses of tires, some being very good, some being not so good. The bill now separates those uses into three tiers. You're going to set the highest tier, and then the statute sets the tier 2 at 50% of that, and tier 3 at 25% of that. So, and the bill also defines fairly closely what end uses fall into each tier. So even though you're not going to be able to monkey around much with moving things between tiers, at least you're going to be able to have a tiered number that will hopefully be somewhat recognizing the relative quality of the end use of the tires. As before, Brian will be distributing the rebates on a quarterly basis with the numbers of end-used tires being then used to pay for the previous quarter. So we'll know how many tires were used, we'll know who used them, and then we'll know how to pay those people, so it will be on a rotating quarterly basis. So in terms of implementation, the next thing that's going to happen is that David Snap and Brian and his unit will be developing, and David's unit will be developing draft regulations. We're going to conduct a stakeholder process as fast as we can. We're going to have to talk later today about probably having a special meeting of the commission in October, because we probably can't wait to November to have you promulgate the rules and then set the initial waste tire fee, because then the effective date can't be until early January, sometime in the first week, but it has to be in place by January 1. So therefore, we're probably going to have to do that in October. So I think what will happen probably is that in August, at the August meeting, we'll probably give you an extensive update on where we are with respect to developing the rules and where we are in the stakeholder process, with the idea that then the rulemaking will probably be in October. So I think that's all I had on that. Any questions on that?
Joe, I just have to ask, is your feeling that this new program, the new statute, improves the old program? In other words, that it was a good thing to allow that old legislation to sunset and start over?
Oh, you're asking me a dangerous question.
I know. Sorry about that.
So, I think as a program have had mixed feelings about the rebates in general, just because in some ways it creates a false market that drives things to happen that may not happen if we didn't monkey with it. On the other hand, I think that the rebates were well received by industry. They were successful in bringing us to 100% reuse of all waste tires we generated in Colorado, and then some. In the last few years of the rebates, we were over 100% recycling, meaning that we were finally mining out tires from the monofills. I think they accomplished a lot while they were in place. And so if you take that as the base tenet, I think this bill, because it sets the tiers, is a slight improvement on the old program.
Hey, Joe, how is the department going to determine what end use goes into which tier? And is there a mechanism that'll be in place to consider where to put a new end use that comes up?
That's a great question for Brian.
Sure.
For the most part, the end uses have already been categorized into the tiers by the law. But with respect to that question, Brian, I don't remember.
Hello, Brian Gaborio from Solid Waste Division.
in the tiers, it has basically defined where the tire-derived products would be falling into, and that's it right there. And so for your first tier, it's crumb rubber and tire-derived fuel. Your second tier is basically molded products and rubber mulch. And then your third tier would be bales and alternatively cover, as well as tire-derived aggregate. So
is there anything there is there anything we know of that's not on that list?
not really. I mean, there's other minor uses that really the state doesn't see much from as far as a per ton. So we're capturing about 95% of it right here in one mechanism or another within those tiers.
Yeah, it looks like they're more general categories than specific end uses. So that answers my question, I think.
One of the things you mentioned was you were pleased to see that more money is going to go towards market development. So in this world where we develop new uses for these tires to continue to mine the monofuels, how will we determine what tier these new things go into?
Well, basically allowing for things such as crumb rubber and rubber mulch, that's typically where those new markets are coming from, such as when they do pyrolysis, you're creating new products, such things that have come out like car belts, phone cases, asphalt. These mechanisms all have some kind of crumb rubber or rubber mulch incorporated into them. So we would be able to kind of look at those products and say, where do they fit? Now, what tier will really depend on how it's manufactured and used. But there's really nothing in there and there's nothing going on right now that's totally new that it wouldn't fall somewhere in one of these three tiers.
Well, in tier one, it does say, and approved by commission rules. So it looks like we would have a role in determining some of that. If there
Correct.
were
I
new
mean,
technology.
the other clean technologies, and right now I couldn't define what that is at this point. Because again, we're using about 95% of what's going on in the state are basically within these tiers. So yes, if we had something coming down the road that, hey, this is new, and we wanted to try to fit it into the program, there are some mechanisms in there to do that.
And so it wouldn't have to go back to the legislature. It would be something that would come back to us.
Correct.
And that would be for all three tiers, because I see it mentions the commission in tier one, but not in the other two.
Well, you have the authority on all of them. Basically, how that's written is how they're going to kind of fall out, but there wouldn't be a reason to go back to the legislators for anything that's really coming down the pipe at this point, unless it was something that wasn't clean, I guess. But it's kind of hard to define what clean technologies is. So.
What's an example of your 5% that are not in the three tiers?
Silage covers is one. There's some minor uses of half tires for different things. I mean, it's just, they're not even measurable really as far as how our program's fallen out the last few years. Dock bumpers. I mean, just kind of real minor things that really
There'd be no rebate for those uses.
They're not really, for those kind of uses, they're so cheap to make that anything that we're giving them as far as a rebate be way over the top of what it would cost to even manufacture or even buy that kind of product. So, I mean, silage covers really come from processing of a tire for some other use, and then they have these sidewalls left over, and then they use them for such. And so before, yeah, they were part of the program, but now they don't fit any of these categories. So that'd be something that we wouldn't consider. And the other big thing here is we don't have any processor rebates available. That's been taken out as well. So we're only going to be looking at end use as defined.
So one, if I'm predicting, which is dangerous to do, but I think one of the big issues that you're going to have to deal with is that what I would predict that we will come to you with as a proposal is is at least a tier one number that is revenue neutral to the end users. In other words, it may be capable of refunding them the entire cost of the creation of that use. If it's fuel, how much did it cost them to create that those tire shreds for fuel? We're not going to propose that they make money on the deal. However, that may not take us to $2 a ton. So it could be that industry will come back and say, well, the statute allows it up to $2. We want $2. And we're going to be telling you that that's going to be revenue positive for the users of these tires. And so that's going to be an issue that we may not be able to resolve with stakeholders. I'm pretty certain
There's been
that
a significant drop off in use of tires in that way.
Sorry.
Can you say it, repeat that again? I'm
Has
sorry.
there been a drop off since we went down to, what is it, 55%?
Well, we're putting those numbers together as we speak. And we might have some preliminary numbers by next week. From what I understand, no, especially for the high-end uses, they're pretty much the same as they were prior to the rebate going away. Where you're going to see some uptick is probably in the low-end uses, tire bales and ADC. So,
I'm glad you're looking at those numbers because I think those would be very helpful to us.
well, they're required to give us those numbers every year through statute. I mean, we can't say this is who's doing what, but instead of trying to forecast or go out to these guys and ask them, hey, what are you going to do next year? We're going to have the numbers in our hands and we're just going to say, well, this is what you did. This is what we think the rate should be. And this is what we're looking for as far as a fee for next year. So.
Yeah, the reason we're only now getting to those numbers is because they're not due to us until April for the previous calendar year. So we're still processing those numbers and making sure that everybody submitted their reports and trying to run down the ones that aren't yet submitted. So we're still putting those numbers together. But it is interesting that the maybe temporary loss of rebates really had no effect. So that, just keep that in your head as we go forward. You ready for me to go to the next one? Thank you, Brian.
Thanks.
So another bill that passed that will not affect you as a commission is Senate Bill 19-192. This had to do with waste diversion. So given that it's a very close tie to what we do here, I thought maybe it would be good to summarize for you what that bill said. It actually set statutory waste diversion goals. And if you remember a couple of years ago, you set waste diversion goals, hoping that maybe someday the legislature would do that. Well, they finally did do that. The diversion goals they set are 32% by 2021, 39% by 2026, and 51% by 2036. Dave, do you know how those compare to the ones they set? I was going to ask Wolf that and I forgot. I don't recall how those compare to the ones you all set. I was going to check that and oh, you can, okay. Well, while she's doing that, the significant thing here is that this bill raises the tipping fee, the solid waste user fee, by a lot. It raises it 50 cents per ton, 15% per cubic yard, which is about 50 cents per ton, through calendar year 2020, starting January 1 of 2020. And then doubles that for 2021, goes to 1.5 times that for 2022, and then ends at 2023 and thereafter at, it's 60 cents per cubic yard, but that equates to $2 a ton. So if you think now, right now the tipping fee, the solid waste user fee is 70 cents per ton. It's almost tripling it for waste diversion purposes. And interestingly enough, it sets up an enterprise fund, which allows it to be Tabor exempt. So it does not account against the Tabor caps because it will have its own board of directors and its own set of rules under the enterprise fund rubric. what the money's going to be used for. And by the way, it's a lot of money. So not only is it a high fee, but of course that is going to turn around to a lot of revenue. And by the end, once it's fully implemented, we think it's going to be in the neighborhood of $12 million a year. Compare that to the current RREO grants of around $4 million a year. So the RREO grants are going to continue at $4 million a year. This is in addition to that. So it is quadrupling the amount of money that's available for waste diversion. The enterprise fund will use that money to then award grants to both commercial and local government entities for implementing things like pay-as-you-throw programs, increased commercial recycling services at commercial buildings and commercial entities, increased organics and C&D waste diversion, and then increased accuracy in measuring the diverted volumes. It is significant to note that, and maybe if the RREO people from the health department were here, they would disagree with that, but they are able to fully award their $4 million a year, but not with what I would call high quality grant proposals. So we are already at $4 million a year, pretty much saturating the list of quality diversion proposals. And now we're about to quadruple that amount of money. So it's just an interesting thing. Sorry for my editorial comments. Go ahead.
Getting a lot of those now that he's a short timer.
So I read that bill, and in the bill it says per cubic yard. So where did you get your conversion factor?
I'm just using the one in our regulations of 3.33 yards per ton. Per tons.
So is that going to be gospel? I mean, since it was legislated per cubic yard?
No, it's going to be charged. Well, that's a great question. I don't know the answer to.
Well, I've already gotten those questions because one, I myself run a cubic yard landfill.
Right, but not all
I
do.
can care less about tons.
Right.
But most landfills are tons. So how are they going to convert it because the legislation does not say that. So I know how I would do it.
Right. Well, that's going to have to probably be subject to a rule by the enterprise fund board. They're probably going to have to determine that. Yeah. Now there was an amendment late in this bill that exempted out from landfills all of the non-recyclable, or at least many of the non-recyclable waste forms. For instance, I can just read you a list of them: asbestos waste, pathological waste, pharmaceutical waste, biohazardous waste, medical waste, exploration and production waste, T-norm waste, grit and sludge, automotive shredder residue, dead animals, et cetera, et cetera, et cetera. So we estimated that would be about 30% of the waste stream would not be charged this fee, but the numbers that I gave you already subtract that out. So that the $12 million a year is what I think the net revenue will be, even with those waste streams exempted out.
No, just a clarification. Do these goals, excuse me, the diversion goals apply statewide? And the reason I ask is I know when we set ours, we kind of separated them out by areas of the state. But will they apply uniformly across the state?
It's front range.
Front range diversion bill again.
I'm sorry.
Okay.
You're right. I forgot
Thank
one
you.
very important thing. This tipping fee only applies to the 13 front range counties. I did forget to tell you that.
Okay.
It does not apply statewide. But again, the numbers of revenue that I gave you already take that into consideration, because about 85% of the solid waste stream goes into front range landfills from the whole state. So the rest of the state is only about 15% of the waste.
And so the people that can apply for the grants they also have to be front range?
Correct.
So the $12 million, what will be available to outside of the front range?
RREO.
Just
The
RREO.
current RREO.
Right. Nothing out of the new revenue.
So the commission will still have to reaffirm these goals since this is just front range in this bill.
That's something for you all to think about. I mean, you can do as you want, because it's true that when you set it, you set the two-tiered goals. The statute only sets the one tier. So, yeah, you might want to do that. Yeah.
But it appears they're the same.
Yes.
For the Front Range.
Yes, it does. Yes. Yes. That question is now answered. Yes. Thank you for pointing that out.
That's an exciting amount of information that I don't know that we intended to have happen.
I think in the bill somewhere it did mention the
mention.
the
Oh,
rates
yeah.
set by
So
the solid
actually
and
it
had,
was-
yeah, it did mention you in like one line of the legislation.
Way to go.
Catherine?
Okay, the only other bill I wanted to mention was the bill that I think we told you about last time that we were running, and it had to do with some litigation that we had lost, that put our enforcement authority at publicly owned landfills in jeopardy. We tried to run a bill that was very short and sweet. I think it only changed about 20 words in the statute, that would give us clear and unambiguous authority going forward at those landfills. We had a sponsor. We were all set to go. We went all the way through legislative drafting, but then late in the session, our sponsor decided not to introduce the bill. I think that had to do with many things, but primarily it had to do with the fact that it got very late in the session, and there were still quite a number of things on the governor's agenda that they were working very hard on, and we fell off the side of the cart. So that's not a huge disaster for us. It's a disappointment, but not a disaster. If the appeals court, which is where that litigation is now, decides in our favor, then it sort of moots the need for a bill anyway. That may happen within the next 8 to 10 months. It may not. So if it does not, I think the department, through Jennifer and hopefully through our department management, will agree to allow us to try to run that bill again next year, which I think will be fine and still timely. So I wanted to give you an update on that, though.
Can you say a few words, I don't know if it's you or Jennifer, about oil and gas conservation commission now needing to coordinate with H&E, specifically air quality plans for making that happen?
So I've been in one meeting on that topic, and what I learned in that meeting was that there have been significant changes to the people that are on the commission and the makeup of the commission and their authority. And then, but outside of that, I think there are talks about how to further coordinate. And but I don't know of any specific plans for that. But I think we could maybe have someone from air quality come in, or executive leadership come and speak to you about that at the next meeting if you would like. Okay.
That'd be great.
Brandy, do you mind coordinating that? Thank you.
Anything else? That was
Oh,
it?
But I actually have one
Uh-oh.
more legislative update
Yeah.
that they probably weren't tracking for you. That is Senate Bill 19-227, which is one of the opioid bills that went through this legislative session. The harm reduction substance use disorders bill will expand and revise the medication take back program, which is the one rule that you all promulgate for the Division of Environmental Health and Sustainability. And that will include allowing the program to collect and dispose of sharps, needles, syringes, and injection devices as a part of that program. So that division will be coming forward with some informational briefings and let you know about their stakeholder process and proposed rules later on, probably in February of 2020.
So there's not a January 1st deadline for that?
There's not a January 1st deadline for them. It's a July 1st, 2020 deadline.
Thank you, Joe.
Okay. Thanks very much, Joe. It's not too late to stay. So next on the agenda is our August agenda. Think we could get that in and before we break for lunch?
Yes, quickly, in light of the need for an October meeting, I'm looking for ideas if you still, want to hold an August session where you travel somewhere. You will be required to attend a meeting on October 15th to meet the deadlines contained within the waste tire legislation. And at that time, you'll also get an update on the medication take back proposed changes. And then that also may impact our November meeting schedule. So
One thing for consideration on the August meeting and maybe doing remote or site tours is that I would love to have John Putnam accompany us on that if you would be interested in that. And that way he could get a little bit of an idea of you guys as well as what kind of facilities we regulate. So
Bora Bora, did you say?
So in light of having to be here in October, I'm opening discussion on what we would like to do for August and November.
Well, I thought there was something that was going to come back to us in August besides.
Joe, our solid waste staff can give an update on the progress of the waste hire rule or proposed regulations.
And if we didn't meet in August, then we wouldn't get that information until October. And so we'd be getting the update and voting at the same meeting.
Or the division could submit to you a memo of
Okay.
letting you know an update. I mean,
I think personally, if we're thinking about canceling a meeting with the October meeting, I'd rather cancel November. Because I do like the site visits and I think we learn a lot. And August is probably better to travel than November. So
And is it a cancel of November or is it moving November's agenda forward?
yeah.
Is there a barrier to doing that?
there is not. I think there might be one, actually, I think the division, the Has Waste program had one tentative item for November, and that can be pushed until February of 2020.
So we're looking at if we continue with the August meeting and then we have to do the October meeting, then there would be no November meeting.
No November.
Speaking as the person who has to drive up the mountains, I'm all in favor of that.
Okay, so in light of still having an August meeting, ideas on where you would like to go? Would you like to stay more local, travel? I'm open and we can find facilities.
I thought we were talking about the mountains when we went out to the east last year.
Oh, okay.
That's how I recall the conversation.
Not any composting facilities?
No comfort. Yeah, right, right.
You promised that there would be no
There were no-
bad odors. Set a bar there for a waste commission.
Would it make sense for you to kind of give us suggestions of types of facilities and where they're located?
Maybe we could have Joe and Doug come up and talk about possibilities for
Yeah.
Yeah, especially if there's anything with the agenda coming up next year, either around
Right.
tires or teen worm or any of those things that make sense to tie into an agenda.
anything interesting.
We could go back to the tire monofill, if you remember.
Well, so maybe get an idea of geography. Where are we talking mountainish communities?
Well, I think we were first asking about agenda that might tie into things, and I don't know if Rocky Flats is on the table.
There's not a whole lot to see at Rocky Flats other than a
There's
big
a
green
beautiful
field.
elk herd out
Elk
there.
herd, nice wildlife out there.
Yes.
It does seem like maybe a teen worm site might be appropriate since that's going to be coming up.
So that would be a water treatment type facility would be my suggestion. So we could look at that.
Yeah, and those are
They're plentiful.
everywhere.
Yes.
And again, we don't necessarily regulate those.
Right.
We'd work with our water quality division to find one that was convenient and
Yeah.
interesting.
Yeah.
But that's easy to do, I think.
Yeah.
Springs.
Linwood Springs.
I mean, the mountain landfills tend to be small, but they also tend to have some really kind of unique issues associated with them. Topography tends to be one, obviously. Temperature tends to be one. Seasonal changes another. Summit County landfill is a really good one. Lake County landfill is a really good one outside of Leadville.
Might be interesting to see some associated with the program that you guys are running for the small landfills too.
Lake County is definitely in that category and not too far off the I-70 corridor.
I guess that would be my question. Are there areas within the state that you have more interaction with or concerns with other than the Denver metro area that you think it would be worth our seeing?
Yeah, I would just add on to that. Last year, it was great being able to go where we went. But I think the local community didn't have a single comment for us. There wasn't really
Right.
engagement. There wasn't, we were there to be able to engage, but they seemed satisfied.
Yeah.
Happy.
Yeah.
Yeah, we just don't tend to get a lot of,
Yes.
unless there's something that we've really riled them up on. I don't know that we're going to get a lot of lovely good.
Well, and I mean, I think that if we are going to be able to, which we're supposed to have a meeting with executive leadership in the next couple of weeks about the landfill bill and whether or not we're going to be moving forward. And if we get an answer on that and small landfill, and we're going to try to go for that again, having you guys visit one of these facilities such as Lake County, where we've actually provided some assistance and talked to, and maybe even have you guys meet with some kind of county folks about what the division has done. I think that might be informative.
Yeah, that was more the point.
agree.
Not
Yeah.
that we were looking for controversial. It
Yeah.
was, let's hear how the division interacts with those local regulators and what are their areas of concern and
And maybe we
How
can
they
find
can-
a place where, because we're going to be working on waste tires, we can talk to somebody who we've done a significant cleanup for. Maybe up there.
One area of the state that we do have some interesting facilities in is the San Luis Valley. I mean, there are several small landfills in the San Luis Valley. There's also one big regional landfill in the valley that's a really interesting multi-county consortium that put together that and built that. There's also, composters. There's potato growers, potato washers. There's just weird things that happen in the valley that are unique in the state. So that's another area that we could think about.
What about you, Doug?
Oh, we don't have a ton of specific facilities in those areas, but if you picked an area, we could look for some corrective action facilities, or I know there's the collection facilities that we worked on that short rulemaking.
Right.
Last year, there is a couple facilities around that are operating now as authorized collection household, or not household, but VSQ collection
Right.
facilities. Might be interesting. I think Pueblo is moving forward on permitting 3 static detonation chambers, which are incinerators, which is a big deal because we don't have hazardous waste incinerators. I think it might be a little early though, even in August, to see much other than a construction pad.
But we could see the failed facility.
Yeah. Well, you saw, you went to the training facility a couple years ago with PCAP. There's not a lot that's still a good tour. You get to see some robotic equipment in that. I think that's always it's pretty interesting because they can show you kind of what the different equipment they're using. So that's always open in Pueblo. But like I said, we don't have a ton of mountain facilities, at least not big facilities.
The abandoned fruit refinery.
Oh, good. Yeah, there is, Dave just pointed out, we've had a long time refinery in Fruta, Colorado.
Oh, right.
That operated. It's been abandoned and it's being cleaned up, but it's been in various stages of cleanup. Well,
Familiar
which
with
is
that.
always an interesting facility to see. I don't know how much is left there though.
Well, we could show before
Right.
pictures and then you see the after. A lot better.
Right. There's it used to be a big refinery and they since have taken a lot of it down.
Still an asphalt plant there.
Is that right? Yeah. Yeah, and it's right on
Smell it all.
Colorado. It's pretty far out there, but there's some areas. Yeah. So I think if you look and find an area, then maybe that's driven by maybe a solid waste facility, then we would look to supplement it with maybe some smaller facilities or something that would be at least in the haz waste.
Go see a dry cleaner.
You can see a dry cleaners if you want to
see dry cleaners.
Big cleanups out there? Big dry cleaner?
Not really. They're all pretty small. You know, we've moved forward a little bit on the PFAS hazardous waste constituent that was added last year, has driven some groundwater sampling at several facilities around the state, and basically all of them are finding it. Not surprising, but not a lot of them that have levels that are above at least at the facility line, above the 70 PPT advisory level. But there is a couple significant ones. They're being driven into further groundwater sampling to confirm and look at seasonal variations. But that's starting to become a big issue, you know, not just around the state, but in the nation. So we could look for maybe a facility doing some testing like that. If you're interested.
So do you have one area of the state or another for me to focus on?
I think the San Luis Valley would be
Yeah, where'd you say
interesting.
Lake County was?
Lake County's Leadville.
Yeah, it's beautiful.
Well, it's gorgeous. Is there enough to support?
Well, so I mean, one thing we could do is we could head out I-70, go south to Leadville, then we could keep going south to the San Luis Valley and then swing back up through the Front Range if you wanted to. I mean, that's quite a drive, but.
We could use Joe's.
Joe, are you buying an RV? They were.
No, I'm
You could host us all.
the Lake County stop would be a 2-hour thing.
Yeah.
It wouldn't be.
But we could see similar facilities in San Luis Valley as the Lake County facility.
Yeah, so we could skip Lake County and Saguache County and Custer County. There's others down there.
Yeah.
Tilapia farm in
Especially the
San Luis
construction in
Valley and
925.
its solid waste management practices.
And you might know more about those than I do. Oh, the alligator farm?
right.
Yeah, there's always that.
We got ostriches too.
Well, it sounded like the San Luis Valley had some of what we're looking for and the potential for there to be some community interest to
Yeah.
talk to us about how it's going. And so if we could hit both of those notes and then work in something hazardous, that seems like.
Well, and the Saguache County landfill actually would be an interesting one. It's about, I don't know, as I recall, I think it's about 30 miles north of Alamosa. The Saguache County commissioners would be very interested in you coming and would give you an earful of a lot of stuff, both good and bad, I think, about us. But their facility just got stuck with, in a way, a recycler that went belly up and left behind a lot of stuff. And so they're now having to deal with that. So it's an interesting facility. It has some groundwater contamination. They've got a cell that's almost full. They're gonna have to decide pretty soon what to do with either closing or putting in a new cell. There's a lot of issues around that one little site. It's an interesting site.
And we just signed a compliance order on consent a few months ago with that facility.
Right, to deal with their recycling problem, yeah.
It's interesting.
Yeah.
A lot of potential.
Yes, we use the waste tire, we use the waste tire fund to get rid of a lot of tires from that facility, actually.
Well, that sounds like it's hitting a number of notes that we're interested in.
And you know, Alamosa probably has some generators for you, and yeah, there's some things we could do down in the valley and bring back to you in terms of proposals to see.
And I'll look into some teen worm stuff as well. We'll try to squeeze that in as well.
So then would you want to look at traveling like August 19th and 20th? Yeah. Well, we have to let everyone know we're coming on very specific dates.
All right.
Well, I am not available those dates. So while I'm not the most important person here, I do want to bring John and go see some of the facilities myself. So, but if that doesn't work for you guys, then
It's not the best
I
date
just
for
can't do
me.
the following week.
Yeah, I could do that.
We say August what?
Yeah.
The 19th, 20th is our regular.
Right.
That would-
But we could
Right.
move that
We can
around.
move it, yes.
And so Jennifer, your availability and John's availability would be before or after that?
I wouldn't know John's, but let me check on mine. I'm hopeful that this far in advance on his calendar that he shouldn't be too booked up. The 13th, the 12th, 13th, 14th all look good for me. And as soon as Brandy gets it scheduled, she or I can circle back with him.
Those dates would also be better for me. We're leaving on a 6-week trip.
Oh.
19.
Oh.
I would just miss it.
So what about the 12th, 13th, 14th for?
I can't do the 14th, but the 12th and 13th are okay. If we're just going to do a day and a half or 2 days.
They have airplanes down there.
Schedule is terrible, so I'll figure out what I.
All of it's bad for you?
But
The 12th through 14th is okay for me.
When's that?
I-25 so torn up, it's going to be torn up for a while too. Just heading down that way. It's always going to be a little precarious.
Yeah, you could do September, early September, then you run into Labor Day.
Yeah.
Yeah.
And
Well,
always will
always
be.
going on
Yeah.
Halloween because-
Yeah,
Well, and we're pulling November for that.
right. October. We don't want to do September and October.
Yeah. So it looks like the most of us could make it that 12th through 13th.
Mm-hmm. 12th and 13th work, yeah.
It's not China.
All right, I will be in touch with more details very soon. But we'll move it to August 12th and 13th for travel time.
And is that all you need from us, Brandy, on the August meeting agenda?
Yes.
So we could break for lunch?
Yes.
All right.
All right.
We're gonna breaking for lunch.
I have one quick announcement, not to be between you and your food. In addition to this being Joe Shefflin's.
No, not yet. Please don't do that yet.
Sorry?
Please don't do that yet.
Okay.